injured by vaccinations, and also from Justice Department and Health and Human Services Department officials. Indiana Congressman Dan Burton chairs the hearing. It's just over 3 hours.
The Committee on Government Reform will come to order. A quorum being present, we'll start our business. I ask unanimous consent that all members and witnesses' written and opening statements be included in the record, and without objection, so ordered. I ask unanimous consent that all articles, exhibits, and extraneous or tabular material referred to be included in the record, and without objection, so ordered. Today, we're going to focus on the government's program for compensating families that experience vaccine injuries. We spent about 2 years conducting oversight on federal vaccine policies. We looked at these issues from almost every angle. We've looked at the issues related to vaccine safety. Much more research needs to be done in this area. We've looked at conflicts of interest in vaccine policymaking. The Department of Health and Human Services has a real problem in this area that we don't believe they're addressing. Today, we're going to look at the National Vaccine Injury Compensation Program. It was created by Congress to compensate families when their children are injured by vaccines. Is it working the way Congress intended? I think the answer is no. I want to make a few preliminary points about the vaccines in general. First, vaccines are an important part of our public health system. They've saved millions of lives. They've helped wipe out crippling diseases. We want children to be protected against infectious diseases. Nothing this committee does should be interpreted as anti-vaccine. Second, we want vaccines to be as safe as possible. No matter how good our vaccines are, there's always room for improvement. The oral polio vaccine saved thousands of children from a crippling disease. It was a good public health tool in its time, but it was not perfect. It had a high rate of adverse events. By doing the research, a new and better vaccine was developed. Today, we're getting the same public health benefit with far fewer side effects with the polio vaccine. Not enough research is being done in this area. Mercury is a good example. For decades, vaccine manufacturers have used mercury preservatives in vaccines. In the past, maybe the benefits outweighed the risks. But today, there's a consensus that mercury, no matter how small the quantity, does not belong in vaccines. The truth is, we just don't know what the health effects of mercury are because the research hasn't been done. We know that some forms of mercury cause neurological disorders. There are some groups of scientists that believe that Alzheimer's and autism are in part caused by the mercury in the vaccines. And I want all the members of Congress to know that the vaccine that they're getting for the flu has mercury in it. It's called thimerosal. And that's a preservative, and some scientists believe it does cause, as a major contributing factor to neurological disorders. And when you go over and get your shot, all you have to do is look at the insert because it does have mercury in it. I'm not saying you shouldn't get a flu shot, but I think you should be aware that there's a growing body of evidence that the mercury does contribute to Alzheimer's and other diseases of that type, and it's in the vaccine. Not enough research has been done to tell us if the mercury preservatives used in vaccines are related to neurological problems, but as I said, there's a growing body of scientists that believe it is. The Institute of Medicine said that a connection is biologically plausible, but there's not enough research to know, and we need to do more research to make sure. When those of us who have really looked at these issues call for more research, and when we say that we should err on the side of caution, I hope we won't be accused of trying to scare the public. We shouldn't bury our heads in the sand when it comes to vaccine safety. The best way to give the American people confidence is to do the research so we can tell the people that their vaccines are as safe as possible and most effective products are as safe as possible. The third point I want to make is this. We know that no matter how safe the vaccine is, a very small number of people are going to be injured. Now, that's a fact. That's why Congress created the Vaccine Injury Compensation Program, to provide compensation to families when their children are injured. My colleague, Mr. Waxman, who I'm very happy is on the committee because he's very familiar with this issue, he wrote the bill that created this program 15 years ago, and he deserves a lot of credit for that. At the time, vaccine manufacturers were faced with a lot of lawsuits. They were threatening to leave the market, and so that would have adversely affected people who needed those vaccines. The stability of our vaccine supply was in question. Mr. Waxman and others stepped in and created this program, and it took a lot of foresight. The program had three basic goals. The first goal was to protect vaccine manufacturers from lawsuits. That was successful. The second goal was to stabilize the supply of vaccines in this country. Again, that was a success. The third goal was to provide compensation to families in a generous way without tying them up in court for years. And on this point, the program has not lived up to expectations. This system was designed to be generous to families whose children were suffering crippling injuries. It was meant to provide compensation quickly, without a lot of legal fighting. On close calls, the families are supposed to get the benefit of the doubt. That's not the way the program has been working today. It had some successes, but it's also had some failures. If you talk to families who've been tied up in this system, it sounds like this program has become every bit as adversarial as the tort system it replaced. Cases drag on for 6 or 8 or 10 years. The GAO said that the average case takes 2 years to complete. A third of the cases take more than 5 years. The government hires teams of medical witnesses to try to disprove families' cases. All of the government's expenses are paid out of the trust fund. Families are not reimbursed for their expenses for years. We're talking about middle-class families who are already paying tens of thousands of dollars every year to take care of severely injured children. We're supposed to be helping these people, but if you talk to some of these families, they feel like they've been put through the ringer by their own government. We have some clear evidence of overzealous conduct on behalf of the government. In the case of the Sword family, which we're going to hear about today, the special master called the Justice Department's lawyer tactics egregious. Quote, respondents' argument of independent corroboration from the records is especially egregious in a situation such as the instant case in which death occurs within 4 hours of vaccination. In the case of the Zulke family, one of the special masters recused himself from the case because he became so frustrated with the government representative. In a case cited in our committee report last year, the special master apologized to the family for the government's conduct. Quote, in the special master's view, respondents' counsel's abrasive, tenacious, obstreperous litigation tactics were inappropriate in a program that is intended to be less adversarial, end quote. We have 3 families here today who are going to talk about their struggles under this program. I'd like to talk about each one of these cases in detail because they're all so compelling. But I don't want to make our witnesses wait any longer than is necessary. Let me just use the Zulke case as an example. Janet Zulke's daughter received her pre-kindergarten vaccinations in 1990. Rachel had a severe reaction almost immediately. Within 6 hours, she was vomiting, and she had fever, severe headaches, and pain in her eyes that made her scream. Within 3 weeks, she was in critical condition, and she had to be medevaced to the hospital at the University of Florida. Today, Rachel is mentally retarded. She has periodic bouts of blindness. She has neurological breakdowns that confine her to a wheelchair, and she'll need care for the rest of her life. A team of medical specialists diagnosed her case as a vaccine-related encephalopathy. That's a condition that's on the vaccine injury table. If you suffer a table injury, you're supposed to get compensation almost automatically. Well, that's not what happened to the Zulkes. This case has dragged on for 9 years. The Zulkes still haven't received 1 penny from the program. The Department of Justice and HHS spent years trying to prove that Rachel's illness was caused by a strep infection. This case dragged on so long, they went through 3 special masters. As I said earlier, 1 special master recused himself from the case because the government would not settle. The Zulkes family finally won their case in July of this year, more than 9 years after they filed their petition. But they're still probably a year away from receiving any compensation. For them, the second phase of the process is just kicking in. There's a long period of negotiations to determine exactly how much money they're entitled to receive. Janet Zulke's already spent over $25,000 out of her own pocket to care for her daughter and to try to win this case. And that was a table injury. This was supposed to be one of the easy cases. Now, not every family has had an experience this bad, but this is not an isolated incident. You hear about these cases over and over again. It's just wrong. Put yourself in their shoes. You have a child who suffers a terrible injury. Maybe you have a child who died like Harold Sword did. That takes a terrible emotional toll on your family. You're faced with hundreds of thousands of dollars in expenses, and on top of that, you have to fight the government with all its resources for years to try to get any help. Somewhere along the way, this program lost its way. The government collects an excise tax on vaccines so it can take care of families like the Zulkis and the Swords and the Rogers. The government has $1.7 billion in this trust fund, and it's growing every year. These families are supposed to get the benefit of the doubt. They're supposed to be treated with compassion, but instead they have to fight the government for years to get any help at all. Now the Justice Department and HHS deserve some credit. They've recognized that there are some problems. They've even backed some reforms that the Congress has not yet approved. They've supported a longer statute of limitations, and that's good. They've supported legislation to authorize interim payments to families when they win the first phase, and that's good. These reforms Congress should enact immediately. Congressman Weldon, on our committee, Dr. Weldon, has introduced legislation that addresses these problems and many others. It's a good bill, and I'm a co-sponsor of it, and I want to thank Dr. Weldon for his hard work on this issue. But the most important reform does not require legislation. It requires the Justice Department to take a long, hard look at the way it does business in this area. And that goes for HHS too. They have to use some common sense. Close calls are supposed to go to the families. The government is not supposed to fight them tooth and nail. Some of these cases don't even look like close calls, and yet the government fights them for years, and that has to stop. Let me conclude by saying this. Vaccinations are important. We want children to be protected against childhood diseases. We should keep trying to make vaccines safer, but most kids who get vaccinated do just fine. But there are cases where children are injured, adults as well, and those are terrible, terrible situations for the families. Instead of treating them like opponents, we have to start treating them with a little more compassion. That's why Congress intended, and what Congress intended when we created this program, and that's what Mr. Waxman intended when he supported and sponsored the legislation, and that's what we want to see happen. I want to thank Mr. Sword and Mrs. Zulki and Mr. Rogers for being here today. We'll be very interested in what you have to say. And I also want to thank the representatives from the Justice Department and HHS for being here. I hope that they can offer us some encouragement that they want to address these problems I just mentioned. And with that, I yield to Mr. Waxman.
Mr. Gilman has to go to the White House, and I'd like to let him go before me.
Thank you.
Can't the president wait? Okay, go ahead, Mr. Gilman.
I'll tell him you asked him to do that. Thank you, Chairman Burton. I want to thank Chairman Waxman, Ranking Minority Member Waxman, for yielding me this time. I welcome the panelists, and I want to thank Chairman Burton for arranging this hearing, which is so important to so many of our people throughout the nation. Chairman Burton and Ranking Member Waxman, you're to be commended for your concern about these important problems. We look forward to hearing from the panelists as our committee continues to examine the effectiveness of the National Vaccine Injury Compensation Program. In 1986, when Mr. Waxman farsightedly had the Congress adopt the National Childhood Vaccine Injury Act, it intended to provide fair compensation to any individuals harmed by vaccines while making certain that the vaccine manufacturers would continue to supply and create safe vaccines to the American public. Instead, this program, jointly administered by the Department of Justice and HHS, has regrettably become bogged down in litigation, with cases lasting years, as our good chairman has noted, facing numerous levels of appeals before any final decisions are made. This program initially, as Mr. Waxman introduced it, was designed to provide fair, expedited compensation to those who may have suffered any vaccine injury. During my years in the Congress, I've been contacted by a number of families in my district, all of whom have experienced varying levels of difficulty and delays with their claims before the compensation program, ranging from being forced to engage in long, drawn-out court battles to outright denial of claims due to administrative changes in definitions and in criteria. One such example, Mr. Chairman, is Tommy Sansone Jr. The family of Tommy Sansone Jr., a former constituent and a police officer, has been trying to receive compensation for the lingering and devastating effects of a DPT vaccine he received when he was only 6 months old. His family attempted to file a claim immediately after the son developed a severe chronic seizure disorder less than 2 weeks after receiving the vaccine. Regrettably, they were told that before a claim can be filed, a family needs to spend more than $1,000 in non-reimbursable vaccine-related expenses before doing so. Since Tommy was covered by his father's insurance plan, it took several months before the Sansones met that monetary requirement. By that time, however, the criteria for the DPT vaccine had been changed, eliminating seizures in a table of related side effects. For 10 years, a substantial percentage of those with brain damage and other symptoms were recognized to be DPT injuries. But by 1985, the year in which Tommy's claim was made, it was no longer recognized. These new definitions have had unintended consequences, using criteria that are so strict that the restitution fund pays fewer claims than ever before, despite the fact that there's over $1.7 billion, capital B, $1.7 billion in that fund today. As a result, families of children like Tommy find it virtually impossible to win a claim in the Vaccine Injury Compensation Program, another unintended consequence. That was over 6 years ago, and thousands of dollars in medical expenses later. Congress envisioned that the National Vaccine Injury Compensation Program would be simple, would be straightforward, and more streamlined to avoid unnecessary typical litigation. But somehow the congressional intent has been lost along the way. Tommy faces a lifetime of crippling seizures and mounting medical expenses, in addition to the emotional strain on him and his family. Hopefully, this hearing will lead to necessary adjustments to the program and finally help children like Tommy receive the compensation to which they're entitled. Mr. Chairman, again, I thank you for conducting this hearing, and Mr. Waxman, we thank you for adopting this measure initially, but hopefully we can get it back on the right track. Thank you, Mr. Chairman.
Mr. Gilman, you might take a look at Dr. Weldon's legislation, because he has a bill that might help correct some of that.
Thank you. I look forward to looking at it.
Mr. Waxman.
Thank you very much, Mr. Chairman, for holding this oversight hearing on the vaccine compensation program. I feel a certain sense of pride as the author of that bill 15 years ago, and there have been some successes with that legislation that are undeniable, and I think we're going to hear some questions raised today about problems in the way the vaccine compensation system has been implemented. But let me give some background, put this in perspective. In 1987, when Congress passed the Vaccine Injury Compensation Act, pharmaceutical companies were threatening to leave the business of manufacturing childhood vaccines, citing, among other things, among other reasons, that the increased litigation was driving them out of producing these vaccines. The United States was facing a very real possibility that we would experience a resurgence of devastating illnesses like polio, which is a debilitating and often fatal disease that infected as many as 20,000 people in some years, or measles, a disease that continues to kill 900,000 people worldwide even today. So in response to this potential public health crisis, Congress created the Vaccine Injury Compensation Program. The purpose of the program was threefold. First, to be a no-fault program to compensate people from the rare but sometimes serious side effects of vaccines. Let me underscore that. When you immunize large numbers of people, there are going to be some rare cases of adverse consequences, very serious adverse consequences. And we have to acknowledge that reality there. And in that case, we decided that we ought to compensate those people. We mandate vaccinations for the most part for all children in this country as a public health preventative. So if somebody's injured, we ought to make sure that that person is compensated. We don't take away their right to sue, but we have a compensation system that offers them an alternative to going into court. Our second objective was to lower, as a result, to lower the number of lawsuits against vaccine companies in order to encourage these companies to stay in the business. And, of course, to ensure that we had a healthy domestic supply of vaccines. And third purpose of the bill was to allay parents' concerns about vaccine safety so that parents would continue to have their children vaccinated. Now, in most respects, this program is working. Immunization rates are high. We rarely see outbreaks of vaccine-preventable diseases like polio or measles. While some vaccine manufacturers have left the vaccine business, they cannot cite liability as a reason for leaving. And finally, people seem generally satisfied with the awards they get under the Vaccine Injury Compensation Program. The act Congress passed allowed people to reject their awards and sue the vaccine manufacturers once they've gone through the program. Well, very few people have gone to court. Most have received compensation through the compensation system and have been quite satisfied with it. Today, we're going to hear from some people who went through the compensation system and did not receive an award to compensate them. And we ought to try to understand why that took place. There seems to be a greater litigiousness on the part of the Department of Justice. I'd like to know why. The purpose of the program was not to replace the tort system with an adversary litigious framework, but to move to a more reasoned source for resolving the claim and getting people compensated who were entitled to be compensated. Now, there is the question, are injuries that people suffered related to the vaccine? Because if you have people come forward and say, well, I had a vaccination and then I had some terrible result, but you can't show that it was related to the vaccine, that's not the purpose of the vaccine compensation system, to award people money if there's no connection between the two. So one of the issues that we have to look at is, what is the standard? Well, we have a table of known reactions to some of these vaccines. Rare, but they do occur. And in that situation, we provide automatic compensation for those who are suffering from what's called on-the-table expectations of possible adverse effects. But then you have people who have adverse effects that are not listed. And should they be compensated, and what burden of proof would they have in order to make their case to the committee that decides the issue? And the present law says that they have to have a preponderance of evidence to show that their injuries were related to the vaccine. Mr. Weldon has suggested in his legislation that we have a justifiable, as I understand the standard he would set in place would be to change the burden of proof requirement from the traditional preponderance of the evidence standard to submitting evidence sufficient to justify a belief by a fair and impartial individual that petitioner's claims are well-grounded. Now, that's a very much different one and a lower standard, and we ought to take a look at it and examine it. I was impressed by the fact that the Bush administration representatives today are going to tell us that they feel very uneasy with that standard. They feel it moves us away from science, a scientific evaluation of the connection between the injury and the vaccine. They feel that it's too low a standard and would compensate people who wouldn't otherwise be compensated. Now, I have to say, well, I'm a liberal Democrat. I'd like to see people compensated if they're hurt. But if you open this thing too wide open, if anybody comes in and has a claim and they can just say, well, I have I can show that a person should be convinced that there's a relationship between my injury and the vaccine, that may open things too broadly. So I want us to look at that issue. We've heard these complaints about the program, specifically about today. We're going to hear from people who feel that they weren't fairly treated. But we've also heard complaints, other complaints, specifically about the statute of limitations, the fact that the program doesn't allow for interim payments for attorney's costs, the length of time it takes to resolve cases, and the difficulty of resolving off-table injury cases. And so I'm pleased we're going to hear from people who can shed some light on these issues, their insights, and as we look at their experiences, will help us understand how this program can be improved. I'm also pleased that we are going to hear from the administration because they've expressed support for certain changes in the program, including increasing the statute of limitations and allowing for interim payments to petitioners' attorneys for their costs. I think those are obvious, important steps in easing the burden of parents to get compensation for vaccine injuries. And I look forward to working with this administration and my colleagues in the Congress in making some of these changes. But as we discuss this vaccine injury program, we have to be mindful that it's impossible to separate the issue of the vaccine injury compensation program from the issue of vaccine supply. This is why I, along with Senator Kennedy, Senator Frist, among others, have asked the General Accounting Office to study why vaccine companies are leaving the business. Currently, the United States is experiencing shortages of childhood vaccines. My office has gotten calls from doctors who cannot get tetanus vaccine even for their high-risk patients. And there are spot shortages of the DTaP vaccine, which protects kids against diphtheria, pertussis, whooping cough, as well as against tetanus. These are serious childhood diseases. We don't want a resurgence of them in the United States. Some providers are also experiencing shortages of new pneumococcal conjugate vaccine, which protects children against diseases caused by pneumococcal bacteria, including meningitis, which can be fatal. So I think we want to find out what's going on in that area, why we are facing these shortages. There's also an issue of the flu vaccine. On average, 20,000 people nationwide die from the flu yearly, and Secretary Thompson is urging people to get flu vaccines this year because the symptoms from the flu are the same as from anthrax. However, we currently don't have enough flu vaccine to immunize everyone. Finally, now that we're facing actual bioterrorism, there's an increasing concern specifically about our supplies of smallpox and anthrax vaccines. There is an anthrax vaccine, there is a smallpox vaccine. I've read media accounts of doctors being flooded with phone calls from people saying they want to take these vaccines. Well, at this time, it would not be prudent to have universal vaccination against smallpox or anthrax. However, I'm sure it would be very reassuring to the public to know that if we needed to, we had adequate supplies of these vaccines. So we ought to be certainly stockpiling and manufacturing at a very fast rate both vaccines. And let me point out that there's something that sometimes comes with being around in a long period of time. When I first got elected to Congress in 1974, in 1975, my first year here, the Ford administration believed that we were facing a worldwide epidemic of what was known as the swine flu. And they immediately moved forward to have every American immunized against the swine flu. Well, people lined up to be immunized. What they didn't recognize, and we always have to keep in mind, is that when you have mass immunization, there are going to be some adverse events. And so some people, intending to prevent this swine flu from attacking them, came down with some very serious side effects that we didn't anticipate. Guillain-Barré syndrome, which caused paralysis in individuals, was creeping up in numbers as a result of this mass immunization. So I say that to point out when people say, well, why don't we have everyone vaccinated for anthrax or everyone vaccinated for smallpox, that we have to be very concerned about the increase in the adverse events, serious adverse events. And we have to balance the risk and the benefit. And it turned out we never did get that swine flu epidemic, but we did get some of those terrible side effects. In the case of childhood vaccines, we know that without immunizations on a mass scale, we will get a resurgence of those diseases. That's why we need to have mass immunizations. But if we're going to have some of those rare events with individuals that are terrible in many cases, not in all, there's some adverse events that are not as serious, but those adverse events ought to be the basis for compensation, and that was the purpose for this compensation system. Well, I mentioned these specific examples of vaccine supply problems to remind us that the Vaccine Injury Compensation Program serves a very important function in helping to ensure the security of the vaccine supply. Making sure we have adequate supplies of vaccine is a public health priority, especially now with the looming fear of bioterrorism. Our goal should be to further shore up our fragile vaccine infrastructure with safe, effective vaccines, and to reassure the public that if they do suffer from the rare but very real side effects of vaccines, that they will be fairly and quickly compensated. I want to thank all the witnesses for being here today. Unfortunately, what happens often in our congressional day is that we have many things scheduled at the same time. When I was chairman of the Health and Environment Subcommittee, I could schedule the hearings to fit my schedule, and I could plan to be there throughout the hearing. Now I'm experiencing what the minority used to experience when the majority used to experience when they were in the minority. Our day is not up to us to schedule. It's up to those other committee chairmen and those on the floor and to set where we have to be. And many times, and today I find myself having to be at a number of places at the same time. I want to assure all the witnesses that I will, if I'm not here personally, I will review their testimony. My staff is here to hear them, and we will work with our colleagues in trying to figure out how to make those necessary changes in the vaccine compensation program to accomplish the goals we had 15 years ago and the goals we still have today. Thank you, Mr. Chairman, for giving me this time to make this lengthy.
Well, as the author of the legislation, I think you probably know as much or more about this than anybody, and we appreciate what you've done and hopefully what you can help us do in the future. Mr. Horn.
Mr. Chairman, I commend you for getting these cases, and I would suggest that we move on and get to questioning and not opening statements.
You yield your time then?
Yes.
I just want to say briefly, first of all, I too have a simultaneous committee hearing going on that I'm one of the Democrats who is needed over there. I'm going to try to come back to this hearing, but I want to say that for those who are here to testify, I think that it's important for the country to hear what you have to say. The efforts that have been made by Mr. Waxman to assure that if injuries do occur, there will be compensation is something that I think this Congress needs to be mindful of with respect to the moral obligation of government to be able to compensate people if they are injured through participating in a government-mandated program or in a program that government is advocating wide subscription by the public. Certainly in this era, vaccinations take on an even greater concern with the mass public. And I think that for those of you who have had families and loved ones in particular who have suffered an injury, it pains me as a member of Congress to even have the thought that our government could be engaging in litigation to contest legitimate claims. And it's something that ought to concern everyone here. And so I appreciate your presence here. I know that along with Mr. Waxman, I'm going to be following very carefully the results of the testimony today. and I look forward to the proceedings, and I thank the chair for calling the hearing.
Thank you, Mr. Kucinich. Dr. Walden.
Thank you, Mr. Chairman. I want to just say that normally I wholeheartedly endorse the sentiments of Mr. Horn at hearings. I think it's important that we get to the testimony as quickly as possible. However, I want to just make two important comments. Number one, I want to welcome Janet Zulke. We're going to hear testimony from her. She's a courageous lady. The chairman has outlined some of the details of her ordeal. I'm sure she'll be going into that in more detail in her testimony. And I hope one of the things that we can get at in this hearing is why does it take so long for some of these cases to work through the system. The other point I want to make is I was practicing medicine when the original bill was passed, and I want to commend the ranking member, Mr. Waxman. It was, I think, a badly needed piece of legislation, and at the time, from my perspective, it was a well-crafted piece of legislation. I think one of the fundamental problems with the system is that, and no offense to my attorney friends on the committee, it's just that we've allowed attorneys the opportunity to manage a lot of this. And I think changing the burden of proof provisions in the law is needed. And I'm certainly open to discussions of modifying my language. I'm quite pleased the administration has endorsed many of the provisions in the bill. And I just want to point out that my bill is definitely very bipartisan. It is supported by a very broad spectrum of members of the House of Representatives. Any piece of legislation that could have Chairman Burton, myself, Jerry Nadler, and Barney Frank on the same piece of legislation has to be correctly labeled as a bipartisan piece of legislation. And frankly, I think if we all sit down and try to work through some of the details on this issue in good faith, we should be able to get this bill marked up in Commerce and possibly pass it out of the House of Representatives on a suspension. There's a pretty broad-based agreement, I think, that some changes need to be made. So I'm looking forward to the testimony of all of our witnesses and certainly my constituent from Satellite Beach, Janet Zulke, and I yield back. Thank you, Mr. Chairman.
Thank you, Dr. Walden. Mr. Cummins? Oh, excuse me, is Mr. Cummins next? Ms. Watson, did you have a comment? Mr. Cummins?
Thank you very much, Mr. Chairman. This committee has held several hearings on the issue of vaccinations, adverse reactions to vaccinations, the Vaccine Injury Compensation Program, vaccinations for our military personnel, and FDA regulations of vaccines. The purpose of today's hearing is to review the Department of Justice's and the Department of Health and Human Resources' implementation of the Vaccine Injury Compensation Program. I fully believe in vaccinations. Vaccines are responsible for the eradication of some diseases that are common in this country. Further, in light of the recent events, there has been increased talk of vaccinating lab technicians, public health workers, law enforcement officers, cleanup crews, and even postal workers as the threat of anthrax exposure widens. Congress adopted the National Childhood Vaccine Injury Act, which established the Vaccine Injury Compensation Program. The program was established for three main reasons. One, to fairly and quickly compensate children who were injured by vaccines. Two, to decrease litigation filed against vaccine manufacturers in order to encourage them to stay in the vaccine market, thus ensuring a sufficient vaccine supply. And three, to reassure parents so that they would continue to immunize their children. Mr. Chairman, I believe the program is working as Mr. Waxman, the author of the original legislation, and Congress intended when it passed it in 1986. Of course, there are some people not fully satisfied with the program. Perhaps the statute of limitations is too short, and perhaps it does take too long to compensate claimants. However, the program has been successful in its policy goals of ensuring vaccine supply and establishing a program for individuals and families injured by childhood vaccines. Congress was responsive to growing concerns of fears about vaccine safety and the return of vaccine preventable diseases by creating a no-fault compensation program for people who were injured by vaccines that are part of the routine childhood immunization schedule. Finally, Congress needs to continue its role to guarantee the safety of vaccines and to ensure that the goals of the program are met in the future. Besides holding hearings on this very important issue, the committee and Congress can update their websites and other forms of communication for easy access to information. No vaccine is perfectly safe, but vaccines are responsible for preventing the spreading of infectious diseases and in some cases eliminating them altogether. Disease prevention is the key to public health. Parents need to be fully informed of the possible adverse effects and alternate immunization schedules. This can be accomplished by their healthcare personnel or through useful websites and timely communication. I look forward to hearing from all of our witnesses today. I know that they are all moving in the right direction, and I thank them for being here. With that, I yield back.
Thank you, Mr. Cummins. Ms. Davis.
Thank you, Mr. Chairman. Just to show that we work in a bipartisan manner, I have 3 committee hearings going on at 11 o'clock. So I will have to excuse myself, and I have to apologize that I won't get to hear the panel, but I will come back to the hearing as soon as I can.
We'll give you information on the hearing as well.
Thank you.
Let's see. Mr. Duncan.
Thank you, Mr. Chairman, and very briefly, I want to first of all thank you for calling this very important hearing. I have some great concern about these vaccinations. I remember Shay Binker, a woman coming to see me at a constituent day in Lenore City, Tennessee, and telling me about her son who was perfectly healthy until he was close to 1 year in age, and she took him for a DPT vaccination, and at the time she came to see me, he was 21 years old, weighed 22 pounds, had continuous convulsions and seizures, projectile vomiting, and all sorts of horrible things on a daily basis. The Dyer family from Knoxville, Tennessee came to me and told me about their son Andy Dyer, who's now 10 years old. When he was 2, he received a DPT vaccination, and his family has been unable to get compensation, although there were 600 incidents from his batch, 78 claims from his lot, 44 of them in Tennessee, including 3 deaths. This is a young boy who can't walk, can't talk, requires full-time care on a 24-hour basis, and his family was told that his 48-hour symptoms were not severe enough, although he stopped suckling. He started continually flicking his ear and having small seizures right after this vaccination. So I have great concern, and I'm looking forward to hearing from these witnesses.
Personnel or through useful websites and timely communication. I look forward to hearing from all of our witnesses today. I know that they are all moving in the right direction, and I thank them for being here. With that, I yield back.
Thank you, Mr. Cummins. Ms. Davis.
Thank you, Mr. Chairman. Just to show that we work in a bipartisan manner, I have 3 committee hearings going on at 11 o'clock. So I will have to excuse myself, and I have to apologize that I won't get to hear the panel, but I will come back to the hearing as soon as I can.
We'll give you information on the hearing as well.
Thank you.
Let's see. Mr. Duncan.
Thank you, Mr. Chairman, and very briefly, I want to first of all thank you for calling this very important hearing. I have some great concern about these vaccinations. I remember Shay Binker, a woman coming to see me at a constituent day in Lenore City, Tennessee, and telling me about her son who was perfectly healthy until he was close to 1 year in age, and she took him for a DPT vaccination, and At the time she came to see me, he was 21 years old, weighed 22 pounds, had continuous convulsions and seizures, projectile vomiting, and all sorts of horrible things on a daily basis. The Dyer family from Knoxville, Tennessee came to me and told me about their son, Andy Dyer, who's now 10 years old. When he was 2, he received a DPT vaccination, and his family has been unable to get compensation, although there were 600 incidents from his batch, 78 claims from his lot, 44 of them in Tennessee, including 3 deaths. This is a young boy who can't walk, can't talk, requires full-time care on a 24-hour basis, and his family was told that his 48-hour symptoms were not severe enough, although he stopped suckling. He started continually flicking his ear and having small seizures right after this vaccination. So I have great concern, and I'm looking forward to hearing from these witnesses. I think this is a program that is crying out for reform, just based on what I've heard from my constituents and from other people from around the country. And so I look forward to the testimony of the witnesses, and I thank you for allowing me to be part of this hearing.
Thank you, Judge Duncan. Ms. Norton, do you have an opening comment?
Mr. Chairman, only to say that I think this is an important and timely hearing that you're holding at a time when terrorism must cause us to encourage people to participate, especially as to children, in programs that provide needed vaccines. Compensation in case of a mishap is very important, but I hope that given the fact that we probably are going to see more and more children and more adults facing the necessity to take vaccines, I hope that this war we are in will spur us into more research, so that whatever fear there is of those vaccines that have caused problems to a few will not become a more generalized fear at a time when, frankly, we can't afford that kind of fear. But part of the reason for that fear is that these vaccines are not always as perfected as they might be. I think our country has done an extraordinary job, given the small number of injuries and deaths which, in fact, come out of vaccinations. Medical science is not perfect, and science is not perfect, but we have certainly gone very far in using vaccines to protect our own public. Now, as we hear that it may become necessary once again to vaccinate people against smallpox, and we know that there are, for a very small number of people, some serious side effects. We need to work harder than ever on making sure that those side effects are conquered and disappear, particularly when it comes to something like smallpox. We can't afford to have people saying, as the smallpox, well, I'm sorry, I don't want that vaccine. I don't want that vaccine. Because as we learn, one person unvaccinated can do great harm. But the only way to instill confidence is not only to say to people, don't worry if something happens, if your child dies, if your child is incapacitated, then there's compensation for you. That's the least we can do. We ought to use what we're going through now to do the kind of stepped-up research that will take away the fear, because we have reduced almost entirely the side effects, and certainly the serious side effects or deaths from vaccine injury. Thank you again, Mr. Chairman, for this important and timely hearing.
Thank you, Ms. Norton. Mr. Schrock?
Mr. Chairman, I concur with Mr. Horn's opinion about opening statements, and because we have to vote, because I'm ready to hear the panel members, I'll have no opening statements.
Thank you, Mr. Schrock. Mr. Clay, do you have any comments?
To meet with the committee today. I especially welcome the parents and spouses who are witnesses today. It is noted that all of the parents and spouses on the panel have family members who have suffered adverse effects as a result of vaccinations. Additionally, I welcome all other witnesses of the panels. Mr. Chairman, my number one focus while I'm in the office is children. I'm a father as you are, and I'm especially grateful that you extend that parental concern through this committee. This hearing examines the injury compensation program that has the purpose of fairly and quickly compensating children who are injured by vaccines, to decrease litigation against manufacturers so as to encourage them to stay in the vaccine market. Overall, the vaccine injury program has worked well. There are still some areas of concern within the program that must be adjusted. We know that the program is not perfect. The intent of this hearing today is to address those areas that need adjustment. And at this point, Mr. Chairman, I ask unanimous consent to enter this statement into the record.
Without objection. Thank you, Mr. Clay. I apologize to the panels. We will get to you just as quickly as this vote is concluded. We have a vote on the floor, so we will recess the committee and be back here in about 10 or 15 minutes, and we'll go to the first panel immediately upon our arrival. Thank you. We stand in recess.
My name's Thad Rogers, and my wife was, I guess, her life was destroyed by a tetanus shot, tetanus vaccine. And before the vaccine, my wife bowled, coached basketball, softball, played tennis with our daughter, and she was just a normal, healthy human being. And she done the motherly thing, you know, drove our son and daughter to activities they were involved in, the basketball, the softball, soccer, tennis, Boy Scouts, Girl Scouts, and she done the household activities like a wife would do. And we also fished for a family. We done everything together as a family. And my wife had the vaccine on February the 15th, 1991. And during the summer of '91, she became unable to drive or do any kind of household work. And I had to start taking the kids to their activities and learn how to do housework and cook and everything else. Most husbands don't know how to do. And at this time, my wife's health was getting worse. Her body was just deteriorating. And we took our last family vacation in the summer of 1996. And ever since then, she has not been able to get out of bed by herself or basically leave the house. And she's in diapers. And right now, she's in a catheter because she's on a special air bed. And someone has to be with her around the clock to feed her, give her medicine, change the diaper, empty the catheter bag. And since 1997, she's had bed baths. Hadn't been able to take a full bath, basically, since she's been sick. And my kids, they help take care of my wife when I'm at work. And our daughter is in her 4th year of college, and our son's in his 2nd year. And soon they'll be starting their own lives. And like I said, they help me take care of her. And in January of 2001, my wife got a bed sore. And she's been in a special air bed since then. Has not been out of it since January. And the bed sore requires dressing twice a day to twice a week whenever it's necessary. And as generally, life with her has been extremely hard. I guess you'd say it's just real hard to get along with because of the illness. and she snaps at everybody and this, that, and the other. It's just been hard. Really has. That's all.
Did you want to make any comment, Mr. Rogers, about the compensation fund at all? Did you receive anything from the compensation fund for the damage that was done by the vaccine? Did you receive any money from them? No money.
Sorry, we have not received anything.
Have you applied for that?
We filed in 1994.
And what happened? Can you just tell us a little bit about that?
Well, you go through the process, and we had the phone conference with the special master and different lawyers. But in June of 2000, we got word that the court concluded that my wife was entitled for help. But, of course, they needed to know, I guess you'd say like dollars and cents, what was required to take care of her. Because I've been taking care of her out of my pocket the whole time, except for the insurance part. And in September of 2001, the case was appealed. And we haven't heard anything since then.
Okay, we'll ask you some questions about that in just a few minutes. Mr. Sword?
Thank you, Mr. Chairman. My name is Harold Sword. I am a lifelong resident of Ohio, a product of Ohio schools and colleges, a veteran of the U.S. Navy, father of 6, and grandparent of 9. Following the Navy, I served a 6-year union apprenticeship, attended school while raising my family, and I've worked for 40 years in the newspaper printing industry. Before I begin, I would like to thank the committee for its work and attention to vaccine injury. I would also like to say that I have no bias against vaccine as a medical treatment as long as it is safe. When vaccine produces something other than safe, I think we are all diminished. I'm here to discuss vaccine injury because my daughter, Natalie Nicole Sword, died of vaccine injury on her birthday at 3 months of age on May 13, 1975, just 4 hours after a childhood VPT vaccination as part of a normal 3-month exam by her doctor. At the time of Natalie's death, there were no requirements to warn parents of adverse vaccine reactions, despite 30 years of documented medical knowledge and research going back into the 1940s of the dangers. We were told she will be sleepy, and that is normal. Consequently, after leaving the doctors on the trip home, excuse me, that included a quick stop for ice cream and to pick up a grapevine. We drove nearer past 7 hospitals and nearly a dozen other emergency medical sites on the route home. Natalie never awoke from the deepening slumber that started around noon while still in a doctor's office. Unconcerned with the slumber, we allowed her to sleep next to us in a bassinet before discovering Natalie not breathing in blue. During our frantic efforts to revive Natalie, I spoke twice to her doctor by phone, commenting to him there was something in the shot that caused a reaction. Just 4 hours after his vaccination of Natalie, her doctor's immediate response to me was denial, saying, "No, it wouldn't be the vaccine. Call me as soon as you get to the hospital." The hospital offered no opinion on cause after talking to the doctor upon our arrival in the unequipped county sheriff's emergency vehicle through miles of major highway construction. That denial continued in a meeting to review the cause of death with Natalie's doctor 2 weeks later following the autopsy. Sadly and outrageously, 30 years after a published article on the vaccine deaths of twin boys in the 1940s, Natalie had died a similar death without warning. Who is at risk, how to know, and is there ever morally acceptable risk of death or injury to any child, even as a well-intended protection, but especially without ever knowing the risk? Yet, completely ignoring the vaccine, we were told by the doctor that performed the autopsy, the coroner, physician, and public health officials that the cause of Natalie's death was something that we had never heard of called SIDS, Sudden Infant Death Syndrome. Webster's dictionary describes SIDS as being an unknown cause. However rare, affected families have both a right and real need to know the truth about vaccine problems. Morality and law should require accurate reporting of cause in public records. When vaccines could be a factor in any injury or death, and information should be provided on the vaccine injury program. More accurate reporting alone could reduce cost and controversy in the vaccine injury claims. In Natalie's case, it was 15 years before we even started to learn the truth, and then it was the result of chance when a co-worker who was deaf noticed a wire story of a deadline for filing vaccine injury claims as we worked on the next newspaper edition. Prior to that article, I knew nothing about a vaccine injury program. I had lived with my suspicions, attending SIDS support groups alone because Natalie's mother had a whole different approach to her grief. I found SIDS logic did not work for me. Although I had strong doubts about the SIDS cause of death ruling, I had not sought legal counsel. Filing suit seemed to be an impossible option because of the SIDS ruling. I did not want to complicate our grief, did not want to hurt the doctor, feeling that nothing we could do would bring Natalie back. I now suspect many people have reacted that way contrary to the government agency adversarial attitudes towards those who managed to discover the vaccine injury compensation program and file claims. Once we found the program late in July, I collected the information and suit was filed near the end of the deadline. However, the suits were separated into two classes by time, and there were many suits filed in a pre-1988 group, creating a huge backlog of cases. From the outset, that volume was a problem for everyone. How that was handled was to wait for the system to get for your case. By the end, for our claim and others, it became an uneven legal field because attorney fees and expenses for expert witnesses and awards all remained under a cap of mid-1980, and inflation eroded all three. The inflation erosion of attorney fees and expert witnesses allowance created limits on resources for claimants that were in assistance for the longest time and also altered the equality of the awards to those who had to endure to the end. Meanwhile, as far as I knew, there were no similar limits on government's ability to contest claims. Could that happen again if max vaccines had to occur for any reason? While time and adversity were problems for the claimants due to the specific limits, time and adversity became a windfall for what became the other side. For my family, there developed a clear sense of betrayal of trust by our government's agents as time passed. Advocates and other claimants I came in contact with believed government was supposed to conduct the vaccine compensation program as not adversarial, timely, and generous. That was not the way it was handled by my experience, and nor was it the experience of some that I heard of. In Natalie's case, years went by, hearings came and went, adversity grew as government experts came with several other possible alternate causes of death that did not agree, not even with one another. It seemed like any answer except vaccine was a possible cause of death and a reason to litigate further because they could. Neither the circumstances nor the valid evidence nor the expert's opinion that were paid for by the program were of any value in resolving that adversity and served at best only to keep the claim alive within the system. As more time passed, the more hearings, the more experts, the more adversity, the more inflation eroded both the resources to continue the claims and the original value of the awards. Government agents, on the hand, had abundant resources and could run out the clock. In our case, we struggled to come up with the money rather than to lose the claim. At one point late in the process, we had to unexpectedly change expert witnesses due to problems unrelated to claim. We had to sacrifice quickly and come up with retainer money for that replacement expert witness. We lost over $1,000 on the first retainer, money we were never able to recover. At the time, we were single parents with split custody and struggling with post-divorce finances. For both of us, it was a lot of money to fly and lodge separately in order to attend and testify in Boston, then later to attend the appeals court hearing here in Washington. Once the appeals court ruled, and mercifully there was not a further appeal, the judgment was paid within a reasonable time. By the end, I am sure Natalie's claim went well over the vaccine injury program's limit on both attorney costs and expert expense witness costs. I paid $10,000 from my portion of the judgment award for experts we used. I'm sure I paid only a portion of those expenses and none of the attorney firm's real cost. Yet when I asked, our attorney, Ron Homer, declined, saying, "You've been through enough, that money should belong to you and your family." I feel all things combined created something other than what was intended in good faith by Congress. I doubt those disadvantages or disparities for claimants were due to any valid intent on the part of Congress, but they may suggest ongoing oversight. When an unexpected injury does occur, I can tell you from experience the last thing a family needs is a misguided lack of information or a complicated ordeal compounded by adversity. What families do need is a reliable safety net. For my family, however, the outcome will not be happily ever after. I will always wonder that,
Take your time.
the true
Take your
effect Natalie's death had on, statistically or otherwise, on our family. Not long after the vaccine injury claim was filed, Natalie's mother became despondent and expressed feelings of hopelessness, unexpectedly separated. During the counseling that followed, she was diagnosed with high depression, but in denial, she declined treatment. A domestic meltdown followed with problems, especially for the children, depression, and I'm old enough now to know that there have been many factors in those matters, but in families there can be complicated social side effects surrounding vaccine injury that have little to do with the original event affecting entire families for a long time. We are urged by the origins of faith and morality to love our neighbor. In fact, we are told in Scripture that love is the law's fulfillment. I urge each of you to consider carefully and tenderly the lives of those who are touched by vaccine injury and this vaccine injury program. Again, I appreciate the opportunity to share this information in my daughter's memory. I pray it contributes something useful and helps all of us somehow. Thank you.
Thank you, Mr. Sword. Dr. Weldon, you want to introduce Ms. Selke?
Thank you, Mr. Chairman. I want to again welcome Janet Zulke for coming here, and we're all looking forward to your testimony. I think it's very important, and I commend you for your willingness to come and provide the information about your experience with the vaccine injury program.
Ms. Selke?
Thank you, Mr. Chairman. Thank you, Congressman Weldon.
Would you pull the mic a little closer,
Yes, sir.
please? Thank you, so we can hear you.
Is that better? Okay, sir. Again, thank you. I appreciate the opportunity to be here. Again, my name is Janet Zulke. I was invited here today concerning my daughter, Rachel Ann. Rachel was adversely affected by her immunization at the age of 5. Rachel will be 17 this December. She suffers from seizures, mental retardation. I must bathe my daughter, take care of all of her personal needs, dress her, help her with feeding. Rachel was declared eligible for compensation in June of this year, and we are now in the life care planning evaluation process. The circumstances surrounding her injury are basically the same. It was Thursday, March 1st of 1990. Rachel again was 5 years old. I had taken her to see her pediatrician, Dr. Richard O'Hearn, as a well child so that she could receive her DPT and OPV immunizations. Within 6 hours of her vaccinations, she was displaying alarming symptoms that were unknown to me. Specifically, vomiting and complaining of severe eye pain. Fever and soreness at the injection site were also present, but those were not unusual to me as a parent. Rachel is my middle child. I have an older daughter and a younger one as well. This was just different. On Friday, March 2nd, I phoned the doctor's office expressing concern about the vomiting and the eye pain. I was told it was unrelated to the vaccines and to give the office a call on Monday if her symptoms had not subsided. Over the weekend, Rachel's vomiting had stopped, but she was still complaining of severe eye pain, and she had become lethargic, very abnormal for Rachel Ann. I was concerned with Rachel's lack of energy and the issue of the persistent eye pain, so much so that when the doctor's office opened on Monday, I was waiting at their door with my daughter. Rachel was seen by a nurse practitioner who diagnosed strep throat. There were no signs being exhibited of sore throat, runny nose, enlarged lymph nodes. She still had a low-grade temperature. Again, a misdiagnosis. Over the next 20 days, Rachel became much more lethargic and complained continuously of eye pain. The severity of her condition became so apparent to me that I phoned Dr. O'Hearn on that Sunday night, and he agreed to meet us in the emergency room at our local facility. Upon completing his examination of Rachel, he told me that something was affecting her central nervous system, that she would need to be admitted, and tests would need to be performed. During that time, a barrage of questions came to me concerning could the child have ingested any household chemicals, pharmaceuticals, etc. It became more apparent in discussion with her pediatrician that the symptoms were the same as she presented on the March 5th visit, but with more acuteness. Rachel was air evacuated to Shands Hospital at the University of Florida in critical condition. The way I learned about the NVIC program was through Dr. O'Hearn. He apparently had checked with the drug manufacturers concerning the lot numbers on the serums that my daughter was given. He was told that there were no other reported cases. It was at that time that he informed me of the NVIC. Rachel's diagnosis then and to date has continued to maintain itself as post-vaccine encephalitis. Filing the claim, I found an individual named Mr. Clifford Shoemaker out of Vienna, Virginia. I read an article in the newspaper by a family that had been affected as well. The mother was gracious enough to speak with me and give me this gentleman's name. Mr. Shoemaker has been representing Rachel since 1991 when the claim was filed. Although Rachel is eligible, she has not received any compensation for her injuries. All expenses have been out of pocket through my family. And as you stated in your opening, sir, I am now going through receipts and trying to obtain this information so that I can be compensated for my out-of-pocket. And in the first 5 years alone, and again, I'm almost going into my 11th year now, I have documented bills showing over $25,000. Again, I was asked about observations regarding the effectiveness of this program. I also have great respect for immunizing your children. I still to this day think that that is a very valuable thing that we must do. I have never fought through a drug manufacturer, nor have I had any sort of confrontation with Dr. O'Hearn. I think he was doing his job. I think Rachel was given a drug that she should have been given. I just feel very badly that it turned out as tragically as it did. In addition to the regular medical exams, Rachel's had at least 30 medical emergencies, which include numerous air evacuations in critical care. Every visit and incident that my daughter has undergone, I have had to provide to the Department of Justice information concerning those admissions. And as you can imagine, over time, she would have an episode, if you will, of one neurological dysfunction or another, and we would get past that. I would submit that information and my child would neurologically fail again. And I would then had to go back through and again provide information concerning that particular episode. It has been the never-ending story. She still has problems. She still requires hospitalizations. And I still, to this day, am required to submit all medical records and information to the Department of Justice. It's time-consuming, and it is not cost-effective. I've had issues where I have been in conversation with, I'll give an example of delays. Over the years, there have been many, many, many deadlines given. I've been in status conferences with the special masters. Again, my daughter has had 4. During one of these specific conferences, the Department of Justice was not prepared, and they requested an extension of time. These extensions were not for days or even weeks. These extensions were for months at a time. I found that unacceptable. We could go 9 months easily without anything being done, and yet we'd come back to the status conference, and again, the individual was allowed to have another deadline. I got so exasperated at one point, and again, I'm speaking to the special master. I didn't show much grace. I was very upset. I voiced my opinion. When is a deadline a deadline? I was not given an answer on that question. The ongoing impression I had and still have is that the Department of Justice made little effort to prepare for these deadlines, and since they were never challenged or commanded to do so, they knew the delay would be granted. There was never any sense of urgency, and even after rescheduling, the DOJ often was still not prepared. Again, I find that unacceptable. I would like to say, of the 4 special masters, Rachel had 1. The first was for 5 to 6 years. The next was for 2 to 3. And she's had 2 in the last 2 years. May I mention names, sir? It's Chief Special Master Golkowitz, actually, was extremely helpful to my family. For the first time in many, many years, I felt like possibly seeing the light at the end of the tunnel. He was the gentleman you referred to before that had to recuse himself. He actually came to me after the very first hearing, which was supposed to be a mediation hearing where the parties had come together on the assumption that we are going to agree. We went through the whole day, got finished, and the DOJ said, sorry, we offer you no settlement. He was incensed, to say the least. He found me in the lobby. You know what his words were. You repeated them before. He was ashamed. He was absolutely ashamed of how everything had transpired and told me that he was sorry, but he was no longer partial to be able to help me. He was no longer impartial. So we were passed on to a 4th special master, who this gentleman is Master Hastings. Master Hastings has finally helped my family to a conclusion, and I am very grateful. The adversarial aspects of this, I think, are just sad. I think Rachel has been treated basically like a criminal, that she's done something wrong, which is not the case. In spite of the early diagnosis that Rachel had experienced severe central nervous system damage, specifically post-vaccinal encephalitis, the DOJ attorney repeatedly attempted to suggest alternative theories of the cause of her injuries. At one point, one of the experts for the DOJ actually stated that it must have been a virus that was in the community. In June of 1999, Rachel's pediatrician, a doctor who has been with her since birth, gave a deposition. That same day, her pediatric neurologist also gave his deposition. Both physicians gave unequivocal testimony that it was their medical opinion that Rachel's injuries were directly caused by her vaccine. Yet in spite of that testimony, the DOJ attorney recommended to the 3rd special master that the government offer nothing. The adversarial process continues to this day. We are now in the life planning process. A life planner has come in for Rachel Ann. She has commenced the evaluation and the estimation of Rachel's lifetime care costs. The DOJ has appointed another life planner who I have still not heard one word from. The young lady has come forward on Rachel's behalf to help. She's prepared. She's ready. I still haven't heard a word from the DOJ. I don't have an appointment time set up. I have nothing. And this is November 1st, and this process has been ongoing since July, not even a phone call. Again, I find that unacceptable. The best evidence of the adversarial process, I think, is in the last line of the decision of the special master. He stated that Rachel's eligibility is, and I quote, a table injury encephalopathy. It is essentially the same diagnosis that was made 11 years ago by her pediatrician and ongoing immunologists and neurologists at Shands Hospital. In my opinion, the DOJ's mission is to investigate crime, prosecute criminals, and enforce the law. Litigation is their primary tool. The NVICP is based on a medical determination. I don't think the DOJ is the correct agency to make medical determinations. Based on my experience, I do not believe the program is working as Congress intended. I've read the proposed changes to the current law, and I very much support those proposed changes. In addition, I have 3 recommendations. I think a total timeline for the entire eligibility determination process to be resolved, a fixed deadline, is needed. I think we need to redefine the goals for the process, ensure those goals include a sense of urgency and a total focus on making a compassionate medical decision. And again, as Harold was explaining, you've got to understand it does not affect just the child. It affects the entire mechanics of your whole family. My 15-year marriage also fell apart from a unit that I thought was very strong. My other 2 children have suffered as well, not being able to do the things possibly because of what their sister's needs were. And I, sir, have not taken a family vacation with my children in 11 years because there's not the money to do that, because I have spent every dime on Rachel's medical needs. And again, to this day, have not received 1 penny in reimbursement. I hope that, excuse me, I do my 3rd recommendation and I'll be finished. Thank you. I think you should create a regular, independent oversight to ensure that the process is achieving the intent of providing a fair, expeditious, and generous outcome to the families. Again, I appreciate the opportunity to be here and for the efforts that you are making for families like mine and for the other people that have graciously appeared today. Thank you.
Well, thank you. I want to thank all 3 of you. I know it's very difficult for you to be here and to testify about your family's problems. I can assure you that we will be overseeing the Justice Department on a regular basis as long as I'm the chairman. And I don't know about my colleagues, but I will be talking to people at the Justice Department, including when Mr. Ashcroft gets some time with the tragedy that's going on here and facing the country, to discuss this as well. Let me start with you, Ms. Zelke. In his written testimony, which we have before us, and we'll hear from Mr. Harris in a little bit, Mr. Harris says that most of the people who complain about the program are people who lost their cases. He says, quote, "I believe it is the denial of scientifically unsupported petitions that may give rise to complaints about the program," end quote. Did you win your case?
Yes, sir. Yes, sir.
How long did it take?
10 years.
Do you have, well, you mentioned the complaints about the program, so I'll skip that. Have you talked to other families with similar complaints?
No, sir. I personally do not know other families with children that have been affected.
Okay. Mr. Sword, did you win or lose your case?
We finally won our case on appeal.
So they fought you all the way through to the appeals process?
Yes.
How long did that take?
We filed the claim when I discovered the information in the fall of 1990. And the final hearing for the appeals was in the spring of 1999, and we were paid in August of 1999.
So it took over 9 years?
Yes.
What kind of complaints do you have about the program?
I don't think it's compassionate enough. I think truthfully that the states need to be comfortable with mandating these vaccines, and I think that the public needs to be assured that the vaccines are both safe, and if there is a rare reaction, that there is a mechanism there as a safety net for them to turn to. One other thing I would say is I don't think there's enough information provided to families about either the dangers of vaccines, or I don't think there's enough provided about the options available to them when some kind of a question about a vaccine incident does occur. And I also think there's a problem with public records and the reporting that goes on in those areas.
Have you talked to any other families that have similar complaints?
I went to a vaccine conference here in Washington sponsored by the National Vaccine Information Center in, I think it was September of 1997. and I met many families at that conference. Since then, I've talked also with people in the state of Ohio. There is an organization in Ohio, an advocacy organization, and I was asked to testify to the Ohio legislature when they were considering mandating hepatitis B. And I told our story basically. And I met people that ranged from people with children to people that were adults. I heard a story about a volunteer fireman who was similarly affected and couldn't get a medical diagnosis. Many of these people are left in limbo, and as I said in my testimony, I think many people either don't know or simply don't approach the program for a variety of different reasons.
Mr. Rogers, I know the government is now appealing your case, but when the special master made his decision last year, did you win or lose?
Won.
You won.
Yes, sir.
But the government, the Justice Department, is appealing your case.
Yes, sir.
Mm-hmm. How long did it take before you won initially?
Like I say, we started in February 15th, 1994.
So it took almost 6 years?
Yes, sir.
Mm-hmm. What kind of complaints would you have about the program?
Well, when we had heard about the program, I live next door to Auburn University. I went to that library. I called it the little green book, the one that Mr. Waxman had sort of designed, and we read it from cover to cover. You know, it sounded pretty interesting, especially the part like when you file it, and then a year after that, everything is taken care of. But this is not true, sir. It is not true at all. It's, even though my wife went through the table of the injury process with the tetanus shot, she fell in that table of what would happen, you know, if the vaccine was bad. But there's just a lot of misinformation in that book that we just didn't understand. And like I say, it's just taking entirely too long. It's, like I say, you know, I told you when you file, it should be over within the year of the process, and it's
been 6 years.
It's, no, sir, it's not.
But the special master and the initial decision was that she be compensated and you be compensated for her injury.
Yes, sir.
And the Justice Department has appealed it.
Yes, sir.
Okay, I see that my time has expired. Mr. Tierney?
Thank you, Mr. Chairman, and thank you for having these hearings. I want to thank all of you for testifying. Any of us that have lost family knows how difficult it is. And I got to tell you, I'm appalled at just thinking of what you've been through in terms of time, whether your claim was ultimately rejected or allowed. The amount of time that you're talking about is just incomprehensible. I mean, I've done products liability cases in half the time of what you're talking about to conclusion. So that you have my sympathies on that, and I look forward to later testimony and later hearings and then some legislation perhaps, or something that resolves even that aspect of it without getting into who's right or who's wrong. It's just beyond comprehension. Let me start from left to right if I could. Mrs. Zolke, you had an attorney named Mr. Shoemaker?
That's correct.
Was he an experienced attorney in matters of this kind?
Apparently he was. Again, I found an article in our local newspaper, a family that had been affected. I tracked them down and spoke with the mother, who again provided me with information concerning Mr. Shoemaker.
And he was aggressive on your behalf? He was a good advocate?
I believe so, yes, sir.
And you have no complaints about his performance, so?
No, sir, I don't.
Okay, and he didn't cause the delays of which you complained?
Not that I am aware of.
Mr. Rogers, did you have an attorney?
Yes, sir, I sure do.
And was he experienced in matters of this kind?
Very.
And did he cause any of the delays or problems that you had in getting attention to your claim?
No, sir. He wanted to get just as much information as possible, you know, before he could really go before anybody. But the only problem with finding attorneys for this situation, to my understanding, this is like a specialized field, and you just don't go to your local attorney and say, help me. Of course, we asked a local attorney, and they said, well, you know, they got the program, but they said, we can't handle anything like this. It's way above our head. Right. So when Mr. Ron Homer is my attorney from Boston, and we finally got in touch with him, and he said he has been dealing with this the last few years.
Well, if he's from Boston, I can tell you he's probably a good guy. Mr. Sword, you also had an attorney with some experience in matters of this kind?
Actually, I had a series of attorneys. I began with an attorney that I had had a relationship with for a number of years in the community, that they were part of a firm that is recognized as being one of the better law firms in the central part of Ohio. They did a referral to a firm in Chicago that had the case for, I don't know, maybe a year or two. And there were some problems within that firm, and the case ended up also in Ron Homer's firm in Boston when it was sent back to the firm in Columbus. And they located Ron Homer, and I can tell you without hesitation that that is excellent representation. I would recommend them to anyone.
Okay. Now, have you been able to get any assistance in compensating your counsel during this period of time?
Actually, the limits were the limits, and as far as I know, I provided staff with a copy of a letter that was sent to me when we did settle that stated that the actual cost of the law firm was probably over twice the allowable limit. They said it was over $60,000 and the cap was $30,000. So they lost a considerable amount of money on that case. In addition to that, we went well over the expense allowances, and I paid additional expense allowances out of the wards as I agreed to before the case was actually resolved. I agreed to go ahead and do that.
In terms of your expert witnesses, am I right in assuming that all of you relied on your counsel to identify and engage expert witnesses on your behalf?
I did.
Mr. Rogers, you did the same?
Yes, sir.
And Ms. Zolke, of course, you did the same?
Absolutely. I didn't know where to go.
Right. Did you find, or Mrs. Zolke, let me ask you something that was curious from your comments. You indicated that the last two masters that you had were good, and you were happy to have their assistance or
Yes,
at least
sir,
their attention
that's
to this case.
correct.
What did they do that made them better than the first two? What were the differences, and why were you unhappy with the first two masters?
I think they moved things along. That was basically, I had a sense of, let's get going.
Progress.
Right, and I didn't have that. Again, the first was John Edwards, who no longer is with the DOJ. I believe he's with HHS. Mm-hmm. And useless, basically, sir.
And I think from your testimony, it was pretty clear that you thought that they were getting continuances without making any particular showing for extraordinary need for more time.
That's correct.
Was that your experience, Mr. Rogers?
Well, in my wife's case, we had to have the phone conference, deal with the special master, the government, and our lawyer, you know, everybody there. See, my wife is a registered pharmacist. She knows more, I'm not trying to be insulting, more than any physician in this whole country. She knows every drug, the whole 9 yards, I mean, everything. And she's just sitting there laughing the whole time at the explanations they were giving, what was wrong with her, which didn't make any sense. I mean, the things that they were saying, it's not possible of what happened to her. I mean, you know, she's not a dummy. She understands every medical term, everything, because a pharmacist is pretty close to being about as a doctor as you can get. And it was just comical the way they were just trying to bullskate us with her problem. It just wasn't very professional. It's just, I don't know. And another thing, the doctor that the government had diagnosed her kind of like as having MS, which that's a symptom. I mean, you know, that's what they're treating her as, even if she doesn't have it. I always thought a physician had to at least look at her or touch her to give a diagnosis. You don't give a diagnosis on telephone.
Hopefully not.
I mean, that's, even though he was giving his expert testimony, a physician should at least look at you, or at least meet you or something. You just don't do it over the telephone.
Of course. I want to thank all three of you. Again, my time is up, but I do appreciate how difficult it was for you, and we're very grateful that you came here today.
Thank you, Mr. Tierney. We'll look forward to working with you on this. Dr. Weldon.
Thank you, Mr. Chairman. Janet, in your negotiations that are underway, will you be able to get any compensation for lost wages?
No, sir.
Can you give us some kind of an impression of how this tragedy has affected your ability to work? How much lost wages have you incurred? I know you've had a lot of out-of-pocket expenses. Can you give us a feeling for how much you've lost because you haven't been able to work?
Well, obviously that would be in the thousands, sir. When Rachel Ann winds up in the hospital, it can be for 2 to 3 weeks at a time, and I am her primary caregiver. I do stay with the child, and again, I'm away from home. I've got to make arrangements for my other 2 children to either stay with family or friends. I did lose my job over this. I was a dental assistant with expanded duties, and I had worked for 15 years for a pedodontist, which is a children's dentist. And Dr. Van had to let me go, understandably. I was unemployed for probably throughout 1990. It was just a hellacious year, just back-to-back issues for Rachel Ann. Then I went to work for my family, who showed me grace, and even on a Friday when I might not be there because I was up at the hospital with Rachel, a check would be put into my account to cover my family's needs. My mother has cancer, and my parents sold the business in November of this past year, a business that we had had for 23 years. I went back into the dental field. I'm working as a surgical assistant now to a maxillofacial oral surgeon, and again, I'm working on a part-time basis. Rachel Ann is picked up at the end of my driveway by a special bus that takes her off to school, and I have to make sure that she's taken care of and on. And again, I have no help. I don't have respite care or anybody else that comes in to help with meeting her needs. And I've got to be there to get her off of the bus. And
so when the settlement is finally reached and you're in the negotiations phase for that, it'll be for her care. You get nothing.
That's correct.
You said in the written testimony, I'm not sure if you mentioned this, that you've had a life planner come in, and the DOJ life planner has not contacted you yet.
That's correct.
But you made a very interesting statement in your written testimony.
Yes,
you said,
I did.
The DOJ life planner that's been assigned your case is, quote, known in the trade to be confrontational and to undervalue costs. Can you explain to the committee how you were provided that information?
Yes.
And the nature of that information you received?
Yeah, well, yes, sir. The information came through Rachel's attorney. They have had to deal with this individual through the DOJ before, so they have past experiences with her. Also, the individual that has been employed now by myself and again through Cliff Shoemaker to come in as the life care planner on Rachel's behalf gave me a heads up so that I would have a clear understanding of what I was coming up against. And now it's the nickel and dime you to death. For every dime that Rachel's physicians will say to the life care planner will be necessary to meet my daughter's needs, apparently the DOJ's side will come in and say, nope, 2 cents is going to cover that. So now this is going to be another ongoing battle, is the way I perceive it. And I have great faith in the people that have taken care of Rachel's needs at this point. I have no reason not to take them at their word on this level.
Were you advised by your counsel how long this process normally takes to come to an agreement? And does this have to go before the special master as well?
I was not given a time frame, and yes, it does now again have to go back in front of the special master and another hearing. Correct.
And another hearing.
Correct.
Okay. And you have no idea how long this will take?
No, sir. I anticipated at least a phone call by now with at least scheduling some sort of a time frame, because again, I've got to organize Rachel's teachers, the guidance counselors, have all of her IEPs individual educational plans so that they can track her course, make arrangements with her PCP so that his time is free, which I've already done that for Ms. Arnold.
PCP, I know
primary
what that
care
is,
physician.
but could you explain to the members what that is?
I'm sorry.
Okay.
A PCP is
So
the primary
the doctor
care
has to
physician.
get involved with the
Absolutely, because he
life care plan.
is her caregiver, and he understands where she's been, where she's at, and where she's going.
So you've already gone through this whole process with your life care planner, and now you have to go through this again with all the parties involved, the
Yes,
therapist,
sir.
the pediatrician, and
Yes, sir.
everybody. Okay. I see that my time has expired, Mr. Chairman.
We'll stay with this panel for a while if you have additional questions. Mr. Duncan?
Thank you, Mr. Chairman. Let me first of all say that my wife and I have 4 children, and I think anyone who's ever had children at least greatly sympathizes with each of you and what you've been through. And I can also tell you, I think it's almost criminal that, or should be, that you've been put through all these years of having to deal with the bureaucratic delays and so forth. I know there are exceptions to almost everything, but you know, state courts, despite having much heavier workloads, usually conclude cases in about half the time on average that the federal government does. And you know, we see all the time that the least efficient way to handle anything is to have the federal government handle it. But I think it's very sad that people are put through years and years and years of dealing with this program. I think you all should know too that most federal judges and most federal hearing officers and special masters almost always rule in favor of the government, because that's usually the easiest way to deal with things. You have won big victories, I think, in having rulings in your favor. But, you know, thinking back to when my children were small, we got all these vaccines, and I had never heard anything about these problems. And I think that almost all parents, I would say 99.9% of parents, don't know about these things and are convinced that they're doing something good for their children. And I know that it must be especially hard for you all to take what happened to you, because I'm sure that you thought you were doing what you should have been doing for your children to make them healthier. Do you all think that enough is being done now to make sure these vaccines are safe? Do you have an opinion about that? Have you read or researched anything about that? Mr. Sword?
Well, as I commented in my testimony, there was about 30 years between the time of the first reports of the twin deaths in the mid-1940s and the time that my daughter died of vaccine injury. My understanding is there have been many, many deaths since then. It was my understanding that I believe it was an acellular vaccine was developed for pertussis in the early 1980s, perhaps in Japan. I may stand corrected if I had that information wrong, but that it was not available in this country for a considerable amount of time, and then it was only available as an option. So I don't think there is enough research, and I don't think there is enough really known about the problems with vaccine injury and the experience, because it just simply isn't well reported.
I think the overwhelming majority of the American people don't even know that this program exists today. And I wonder, I've seen where there have been 6,000 claims filed, but I wonder how many thousands of others there are that have been told that it was not the vaccine, or they didn't figure it out. Do you all think that that's happened, or that there are a lot of people who don't know about this? What do you say about that, Ms. Selke?
All right. I think that's factual. I think people aren't aware of it. I didn't know anything about it until Rachel's pediatrician put me onto this path. And again, I have 3 children. I must say that I heard Mr. Sword's comments before. My children now, I'm past the immunization aspect, and so I'm probably not as informed as I should be in helping other people. I am aware of the fact that at Dr. O'Hearn's office, Rachel's physician, everybody that comes in with the child is required to read this full booklet that gives all symptoms, side effects, adverse reactions, and they must initial each page that they have understood clearly what could happen to their child. And then that information is then documented and put into each child's chart. I think that is extremely helpful.
Yes, sir, Mr. Sword.
My suspicion is that this may very well begin in the medical training process, both for doctors and nurses, and that it may very well be that there is not enough sensitivity on the part of the medical community in the training process to adequately ensure that either the medical providers or the patients are adequately informed in an appropriate way, not so as to scare people, but to treat them with the care that they really need, and to provide to them the information and caution that necessary in order to prevent a lot of these things from going well beyond what they might otherwise go.
Finally, let me just mention, we're going to hear on the next panel a witness who will say that the Justice Department handles these cases in a cooperative and non-adversarial fashion, and that they're much more cooperative than other similar types of cases. I take it none of you have had that have found that to be true. Is that correct?
That's correct, and I'd like to be on that panel instead of this one.
Well, do you think that some of these companies that there's some big money behind some of these companies that produce these vaccines? I mean, so often what we find in these things is the money that's behind it. In other words, they convince the medical establishment that something is good because they're making huge profits out of it. Do you think that enters in at all? Or why do you think they say that companies are getting out of the vaccine business now, the childhood vaccine business? Have you looked into that at all, Mr. Sword?
I have not looked into that, but I always had the feeling from the people that I came in contact with and from the attorneys that I came in contact with that there was a giant standing in the shadows of this whole thing, and that that giant had a lot of influence. On the other side of that, you have children, you have a variety of different kinds of people that are mandated as a condition of employment to take these vaccines. You have policemen, firemen, doctors, nurses, and so forth, who are all, so you have this balance here. And the government has to, in some ways, sort that out. But quite frankly, I just don't think that the absence of some kind of oversight because of this presence of these vaccine manufacturers, the possibility of a revolving door, and as the chairman stated in his opening statement, the conflicts at the government agencies, that there can ever be a resolution to this without some kind of ongoing congressional oversight to this.
Thank you very much, Mr. Chairman.
Thank you, Judge. Let me ask you a question, Mr. Sword. You said that initially somebody said that your daughter died of SIDS?
That's correct. And that was a common diagnosis of cause of death. As my understanding was, there were a lot of these cases that were misdiagnosed from the very beginning as being SIDS.
We have known throughout the country that there were a lot of children that died from SIDS, And there's been some concern that those may not have been just normal ways for children to die, but that they were as a result of vaccines that were given to the children. And I think we ought to take a look at that and see if we can find any statistical data to find out when children who died with SIDS got vaccinations and the proximity of that time to their death, just to have some statistical data. So can we check into that? Let me ask you a couple questions, Ms. Sulky. In his written statement, Mr. Harris, who will be on the next panel, says the Justice Department lawyers are cooperative and non-adversarial. I know you've answered this a little bit. He says the Justice Department undertakes its responsibilities in a more cooperative manner than would be expected from defendants in civil litigation. He also says, I do not believe that the manner in which the VICP cases are processed has become more adversarial. In fact, I believe it's quite to the contrary. And would you once more tell me, each one of you, what you think about that statement?
Well, sir, I don't think I can really tell you what I think about that statement, but I don't think it's factual.
I think you just did.
Okay, sir.
Mr. Rogers?
Well, this whole situation is really hard to understand, but I really wish my wife could have come and really hear it from the horse's mouth, because it's really hard to interpret, you know, everything she's gone through. And one thing, I don't really think the public really knows about this. They just take stuff for granted and that and the other, but I just think a lot of people are getting run around on this. We're just not getting anything professional out of it.
Well, we'll try to make sure the public knows more about it. Mr. Sword?
I guess it's depending on how you define cooperative and how you define non-adversarial and so forth and so on. In my case, I thought it was rather adversarial to a fault. Other cases that I've heard of, similarly kinds of thing, I've heard statistics that somewhere around the area of 2/3 of the claims were rejected for pertussis deaths, and so I think on the whole there may be some effort on the government's part to do that, but I don't think they're doing nearly enough if they are, and they should make a better effort in good faith.
Ms. Sulky, did you ever observe a special master lose his temper or lose his patience with a Justice Department lawyer?
Yes, sir.
What happened? Tell me what happened.
That was in the second hearing.
And what did he say? What happened?
I'm sorry, sir, I cannot give it to you verbatim at this point, but some comments were made, and Special Master did get a little incensed over it. One thing that does stick in my mind is at the end of that particular hearing, and again, this is the second hearing, the attorney for the DOJ said, oh, by the way, there is a piece of evidence that we don't have. And it turns out this piece of evidence he had desired, he'd known about for 9 years. And now at the end, literally the end, the closure of that hearing, I also lost my temper.
He asked for evidence that had been known for 9 years?
Yes, sir, and he said parts of it were not available. It had to do with slides of my daughter's brain tissue because she's had 2 open brain biopsies. And he was stating that part of that material had never been received, and the Special Master wanted to know, well, what took you so long to come up, you know, and say something? Now is a very inappropriate time, and you may not continue with trying to obtain that.
Well,
the hearing was closed.
I'd like to maybe you can give us the name of that attorney. I'd like to check on that.
Yes, sir.
Mr. Sword, did you find the Justice Department to be cooperative and not adversarial in your case?
I didn't feel that they were cooperative. I felt that it was, they came with 3 different causes of death that didn't agree with one another. We got into the hearing in Boston, and they had an expert there who kept nodding out in the first part of the proceedings. And as she proceeded into her testimony, this woman kind of led to a fantasy testimony that if there had been the technology at the time of Natalie's death that existed now, she could have made a different diagnosis. And I don't know how you deal with that kind of a fantasy when you're talking about facts and when you're talking about what was available in the records and so forth. And I kind of sit back in my chair and I started to listen to this, and quite frankly, it upset me so bad that I had to leave the room. I left the room.
So you don't think she had the expertise necessary to actually make comments?
I think some of these people come in there and they make their living doing adverse testimony, quite frankly.
Mm-hmm. How about you, Mr. Rogers?
Well, I know they got their job to do, but it's...
Well, you were in meetings with these people. What kind of response did you have in the meetings?
Well, we just did not understand what they were going after. I mean, I know, you know, my wife being an adult, which is totally different than a child having this problem. They kept going back to things that had happened to her years prior to anything. Like, you know, she had vertigo at one time, and they said, well, if you have a tetanus shot and you have vertigo, you can have MS and blah, 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 which is not really true to a point. And with her expertise as far as medicine, she just didn't believe half the stuff they were telling us. But the special master, evidently she's got a lot of medical knowledge because she knew exactly what was going on, but you know, she's supposed to be the deciding factor in all this.
My time's just about up. Did you think that the government was trying to disprove your case? I mean, they weren't trying to work with you, or were they working with you, or were they trying to disprove your case?
I really believe they just trying to disprove it. They just couldn't believe it's true.
How about you, Mr. Sword?
I don't think there was any question that was what was at the core of what motivated them. They were attempting as desperately as they could to disprove that case.
Ms. Salke?
Same exact thing. That's exactly my words. That works for me.
Mr. Chairman, you have any questions?
No, thank you. I think you've been through enough. Thank you.
Any questions? I think that suffices. If you have any additional comments you'd like to make to the committee, we'd like to have those. We're going to have, when we come back from votes, we've got a series of votes. We're going to have the other panel from the Justice Department and HHS. If you'd like to stay around, we might solicit some comments from you at the conclusion of their remarks. And with that, we stand in recess to the fall of the gavel, which should be in just a few minutes after the final vote. I think we have, what, 2-3 votes? We have
Chairman,
3 votes, so it'll probably be a half an hour before we get back. We will once again call the committee to order, and we'll now hear testimony from the second witness panel. Thomas Balbier and John Euler, would you please approach the committee table there? And who else do we have?
Oh, it's Mr. Harris.
Oh, Mr. Harris. Excuse me, Mr. Harris. Do you swear to tell the whole truth and nothing but the truth, so help you God? See. Which one of you replaces Mr. Euler? I guess Mr. Harris does. Okay. Do you have opening statements? We'll start with you, Mr. Balbier. Can you pull the mic close and be sure you turn it on there? Okay, thank you.
Good afternoon, Mr. Burton. Mr. Chairman and members of the committee, I'm very pleased to be here this morning to talk to you about the National Vaccine Injury Compensation Program. The National Vaccine Injury Compensation Program provides a unique service to families suffering through one of the most difficult experiences imaginable. It makes a system available through which families can receive financial help quickly while still preserving their rights to file suit in the tort system. The program significantly reduces, but it cannot eliminate, the tension and adversity inherent with any litigation process for resolving claims. I heard members discuss earlier this morning that I would be coming here and talking about a system that was non-adversarial. You will not hear me say that. I've been saying for years that the system is designed to be less adversarial than the tort system that people otherwise would have to go through, and it is. I was asked specifically to address three major issues in my testimony this morning. They are complaints that the statute of limitations is too narrow and excludes families from the program. Complaints that the inability to make interim payments to petitioners places them at a disadvantage, and complaints that the program has in general become too litigious and adversarial. We have attempted to address these issues through a wide variety of methods. In June 1999, a draft bill entitled the Vaccine Injury Compensation Program Amendments of 1999 was sent to Congress. This proposed bill contains specific legislative proposals that addressed each one of these issues noted above. I also heard earlier a recommendation that there should be an independent group to provide oversight for the compensation program. That group exists. Those recommendations came from that group. The group developed these proposals we developed the proposal, I should say, based on recommendations from our Advisory Commission on Childhood Vaccines, comprised of medical professionals with expertise in pediatrics, attorneys, including those representing families filing under the program, and equally important, parents of children injured by very rare but serious adverse reactions to childhood vaccines. One of these proposals would extend the current statute of limitations from 3 years for injury claims and 2 years for death claims to 6 years for those claiming injury or death resulting from a covered vaccine. Another proposal would permit the interim payment of litigation costs after a determination that the petitioner is entitled to compensation. Another would allow compensation for family counseling and costs to families related to establishing a guardianship or a conservatorship. Other proposed legislative changes would address the rulemaking process for changes to the vaccine injury table. Currently, the process for changing the table requires a period of 180 days for public comment, including the opportunity for a public hearing. During the last public hearing for proposed changes to the table, no member of the public attended the hearing. Decreasing the length of time for public comment and eliminating the mandate for a public hearing will enable the program to make needed changes, including the addition of injuries to the vaccine injury table in a more efficient manner. The administration supports these proposals. The statute of limitations is extended, potentially enabling more families to seek compensation. Also, the proposal recognizes and attempts to ease some of the financial burdens of petitioners. It is critical to remember that although the program is far less adversarial than the tort system, which it was designed to replace, it was established for a very specific group of intended beneficiaries, The program encourages anyone who believes they have a condition caused or significantly aggravated by a childhood vaccine to file a petition for compensation. Petitioners' rights, as you heard, are vigorously advocated by their attorneys, who are paid reasonable attorney fees and costs regardless of whether petitioners are compensated, so long as there is a reasonable basis for the claim and it is brought in good faith. However, the program was never intended to serve as a compensation source for a wide range of naturally occurring illnesses and conditions, which unfortunately affect many of our children. I also was asked to discuss changes to the vaccine injury table. We have amended the table twice so far, in 1995 and 1997. I spoke extensively to those changes when I testified before this committee. We now begun the process of making further changes to the vaccine injury table. The most important of these changes is to add intussusception, a telescoping of the intestine, as an injury associated with the rotavirus vaccine. Rotavirus is a childhood vaccine licensed by the Food and Drug Administration in August 1998. A series of reports to the Adverse Event Reporting System found that some infants developed intussusception after receiving the vaccine. The VAERS system, as we call it, is a signaling system that has been set up to monitor adverse events. The Centers for Disease Control and Prevention, based on this signal that we received from the VAERS system, then recommended that healthcare providers and parents postpone the use of rotavirus vaccine while we looked into that further. Shortly thereafter, the manufacturer voluntarily withdrew the vaccine from the market. After consulting with our Advisory Commission on Childhood Vaccines, we then published a notice in the Federal Register on July 13th this year. The notice would add intussusception as a table injury using criteria based on scientific data currently used by HHS and the Department of Justice for recommendations to the court on compensation. Already, 4 claims of intussusception associated with the rotavirus have been compensated. In addition, we have taken steps to ensure that potential claimants are notified about their ability to file a claim with the program. We have developed a press release, which was distributed on July 25th. We participated in a conference call with state and territorial health officials, asking them to notify all who had reported intussusception following rotavirus immunization, and we sent a follow-up letter also. We've been publicizing this change on our website and through our outreach efforts. All indications are that the program is working very much as intended by Congress. The process of determining whether and at what level compensation should be awarded will always involve conflicting opinions and a natural tension. There will always be program areas that can be improved, and we continue to try to implement initiatives to address these areas. The program has always been open to advice from all interested parties, and mechanisms are in place to ensure that varied interests of families, healthcare professionals, attorneys, and the vaccine industry are represented in a regular public forum. The Advisory Commission on Childhood Vaccines, with its widely diverse membership, brings good balance of perspective and has been instrumental in identifying program improvements that have consensus support. The ACCV was established by the Act, and I quote from the Act, to advise the Secretary of HHS on the implementation of the program. That's very broad oversight responsibility. The diverse body has provided constant oversight of the operation of the program, advised the Secretary on each and every modification of the vaccine injury table, also as required by statute, and has made numerous legislative and administrative recommendations over the years aimed at improving the operation of the program. The ACCV developed and approved legislative proposals that I mentioned previously. The Department remains committed to making this program and to making ongoing improvements to the program so that children and families can reap the benefits of the program in, and I quote from the statute, the most efficient and fair manner possible. Thank you once again for allowing me to come here today to tell you about the National Vaccine Injury Compensation Program. I'll be pleased to answer any additional questions you may have. Thank you.
Mr. Harris.
Good afternoon,
Chairman Burton and members of the committee, I'd like to thank you for this opportunity to appear before you this afternoon on behalf of the administration. So that I may limit my remarks, I request that my full written statement in our views letter to you, Mr. Chairman, dated October 17th, be entered into the record. In the early 1980s, Congress faced a looming public health crisis concerning injury from immunizations, which involved complex, fiercely debated medical issues overlaid with the emotion of personal loss and tragedy in individual cases. I've sat through the prior panel and we've heard testimony to this effect this morning. In order to stabilize our nation's supply of vaccines and promote our universal vaccination policy to combat childhood disease, Congress established the Vaccine Injury Compensation Program. Petitioners are afforded under this program a more streamlined system of recovery with free counsel provided in each case, in which their meaningful participation in the process is assured. This supply of life-saving vaccines is protected, and a safer, better system of vaccines is currently being developed. Vaccines have improved the lives of millions of Americans. This program has been a cornerstone of the nation's ability to achieve these important objectives. The Justice Department's role is to implement the statute and to uphold the provisions of the Act. By design, this is a program rooted in science. Congress set forth specific eligibility criteria based on the most current and accurate scientific evidence available. We at the Justice Department ensure that fair compensation is provided to those who meet the eligibility criteria determined by Congress, and that the Vaccine Injury Trust Fund is protected against claims that do not meet this standard. Over the past 5 years, approximately half of all cases have been compensated. The use of alternative dispute resolution has increased threefold in the last 2 years. We have initiated efforts to further expedite case processing by organizing a group of special masters, members of petitioners' bar, parents, and HHS staff to review and revise the court's guidelines for practice. We have supported many legislative proposals that will benefit petitioners, such as an extension of the statute of limitations and payment of interim litigation costs, as described in greater detail in our letter to the chairman. We rarely appeal cases to the Court of Federal Claims, and even less frequently to the Court of Appeals for the Federal Circuit. Of the 5,400 cases resolved since 1988, 109 cases have been appealed to the Federal Circuit. The government has appealed only 13 of those cases. Most significantly, since 1993, we've appealed only one case to the Federal Circuit, and that was 3 years ago in 1988. In consideration of all this, I simply cannot agree with any suggestion or accusation that the program has become more litigious. It simply has not. Rather, I think it has become less so. The language of the Act calls for a less adversarial, expeditious, and informal proceeding. The Justice Department has gone to great lengths to fulfill this congressional objective. We collaborate with the court and opposing counsel in developing creative and novel approaches to resolving each claim. As such, the Justice Department has developed a cooperative atmosphere to move cases along. Our initiatives have contributed to promoting an atmosphere of cooperation among all parties involved. Admittedly, some cases are prolonged or drawn out for various reasons, and you've heard stories again from families today that illustrate such cases. Resolution of cases simply cannot always be accomplished as quickly as we would prefer. There exists an obvious tension between efficiency and the important principle of due process. The issues can be difficult and complex. For example, in the entitlement phase, the concept of causality can be difficult to prove. as the Institute of Medicine recognizes, not the Justice Department. The arousal of one's suspicion that a vaccine might be the cause of an adverse event that occurs within hours, days, or weeks following the receipt of the vaccine is natural and understandable. But the mere fact that B follows A does not mean that A caused B. It is for this reason that the Act requires scientific evidence that the injury is related to the vaccine and forbids payment of compensation based on the claims of a petitioner alone. We cannot ignore the statutory criteria or the consensus of the scientific community on medical causation issues. With regard to determining compensation to be awarded, Congress has set forth a detailed list of categories of compensable items. The amount sought is frequently in excess of several $1 million. While often time-consuming, the key is that the program process is far more thoughtful and tailored as compared with other alternatives. The goal is no less than establishing a custom-tailored plan of lifetime medical care, and in as many as 90% of the cases, this is an issue settled by the parties. Bless you. In short, I firmly believe that the program is working as designed. As with any government program with specific criteria, there will be applicants who are dissatisfied, even among those who are awarded compensation. The debate and the emotion in these cases will never be eliminated, understandably, but an efficient mechanism is in place to address these difficult issues. To date, almost 1,700 families have been compensated nearly $1.3 billion. This is an outstanding measure of this program's success. The truth is that these families would have stood little, if any, chance of obtaining any relief in the traditional tort system. Mr. Chairman, members of the committee, I thank you again for this opportunity, and I'll be pleased to answer your questions.
How many cases have been filed?
In the life of the program, there have been roughly 6,000 cases filed.
And how many did you settle?
54 have been adjudicated, and how many have been settled? I couldn't give you that number.
I think you just gave a figure there of 1,000 something, wasn't it?
We have paid compensation to 1,700 families.
So less than a third have received compensation.
In the early part of the program, clearly, there was a tendency not to pay petitioners, but that percentage has gone up, Mr. Chairman.
But there was a tendency not to pay.
Yes, and we've worked closely with
How long have you been doing this, Mr. Harris?
How long have I been on the job? Since July of this year, sir.
Well, where did you get all this expertise? I mean, it's kind of amazing that you have all the answers so quickly, and you've just done it since July?
Yes, sir. Do my homework.
Oh, okay. Well, that's very good. I appreciate the opening statements, but what I didn't hear was any meaningful discussion of what we heard this morning. What do you think about the 3 families that were here this morning?
Well,
I mean, obviously, you've only been on the job 3 or 4 months, so
clearly,
maybe you didn't study these 3 cases, but they've been going on from 6 to 10 years.
Actually, I have studied those.
Okay, well, then why were they paid if there was no merit to their case?
2 of the cases, as you recognize, Mr. Chairman and members of the committee, are cases that are still pending. And
why are they pending?
I cannot comment on specific circumstances of open cases.
But they're being appealed, right?
2 of the cases this morning are being appealed.
Well,
that's correct.
For a layman like myself, tell me, a special master says they should be paid, right?
Correct.
Okay.
In certain cases.
Yeah, and then if the Justice Department doesn't agree, then they appeal it.
Correct.
I see.
Rarely. Very rarely do we appeal.
We had 2 of those cases this morning, didn't we?
That's correct, and which is why what we heard this morning, as emotional and tragic as those cases are, they're not a representative sample of what we deal with. Let me throw out some numbers.
Well, let me
300.
Let me just interrupt you real quickly.
Sure.
You say they're not representative of what you deal with, and yet you said there's been over 6,000 cases filed, and you gave compensation to less than a third of that. Now you have the thing that's interesting is that, and I'll be happy to bring you and Mr. Balbier back here every week or every month if you like, and bring 3 or 4 more people in and have them testify again and again and again about the shortcomings of the system. I'll be very happy to do that if you guys want to spend the rest of your life before my committee. I don't have any problem with that. But I see no reason to do that because we had 3 examples this morning. And what I can't understand is why these people have been judged to be in compliance with the statute and should be paid. One of them has been compensated, is being compensated. And the other 2, the special master agreed. One of them, I think, had 3 or 4 special masters, but they have been, it has been agreed, and yet the Justice Department decides to appeal the case.
Mr. Burton?
I'd like to answer the question about appeals, because one might get the impression that our tendency is to appeal, and that is not the case. Of the 335 cases that have been appealed to the Court of Federal Claims in the history of the program for entitlement or damages issues, the department has only appealed 57 times. All the other appeals have been by petitioner. It's important to note that.
What happened on those 57 cases?
What happened in each case?
I mean, how many were settled in favor of the Justice Department, how many were not?
I could get that, be happy to get that information for you.
Well, wait a minute. You said you've been studying this issue. 57 cases were appealed, and you don't know how many you guys won or lost?
We have that information, but I'm not a statistician, and I can't spit out every.
But that's very important.
It is important. I'd be happy to get that information.
Because if the Justice Department is appealing these cases and you're not winning, it may be an indication that some of these, the special master may know what they're doing. And they may be cases that shouldn't be dragged out for months and years while these people suffer. Let me ask a few questions here. Did Mrs. Zulke, she didn't lose her case. Mr. Sword didn't lose his case. Mr. Rogers hasn't lost his case. Do you think that those complaints that you heard this morning were just sour grapes?
Well, I would respectfully have to say that a characterization that they haven't lost the case would be unfair because the cases are still pending. And I do not think it's sour grapes. I think it's horrible what has happened to these families. And the problem in each of these cases, given the complexities of the medical and scientific issues involved, overlaid with the emotion, is that no matter how efficient our process is and respectful of due process rights, given the fact that there's collateral repercussions to the injuries that are involved.
Okay, well,
we heard breakup of families. That no matter how much we compensate these cases, people are going to be dissatisfied.
Let's go through the process. We have a special master that's appointed by the court, right?
Correct.
And the special master goes into all the details, looks at the medical evidence, listens to the testimony and everything else, and the special master makes a decision. Is that correct, after studying the issue and hearing all the testimony?
That would be correct, sir.
Okay, so the special master makes a decision. In several of those cases, they had more than one special master. And you heard the outcomes. The special masters in all 3 cases agreed that compensation should be paid. You, in 2 cases, have decided to appeal those cases, and those cases have been going on from 6 to 10 years.
Right. And the answer to your question is, there are occasions when we do not agree with the special master, but there are rarely occasions we don't agree with the special master that we feel so strongly to take these cases on appeal. In the last 4 years, we've only taken 6 cases on appeal. There are currently about 700 cases pending. So any impression that we're just willy-nilly taking cases to appeal in an overzealous, litigious fashion would be unfair.
Excuse me, now, Mrs. Zulke's case is not being appealed. And Mr. And then whose case? The Sword case was appealed, but you lost. So 2 of the 3
Correct.
have been appealed, but they've been settled. So the third one is the only one that's on appeal now, right?
I said 2 were appealed, correct.
2 were appealed, but you lost 2 of them, or 1 of them, right?
One of the cases is still pending. One, we lost. The Sword case is a closed case.
You lost?
Appealed, correct. We appealed that case from the special master to the Court of Federal Claims.
Does it bother you when you appeal a case like that and you lose? Does it bother you that you've dragged a case on for 6 or 8 years, and when Congress passed this, you stated the intent of Congress? I was here. I was one of the people that was involved in the decision-making process to pass that legislation. And it was our intent to make this much less adversarial for people who had to go through the trauma of having a child or a sibling or a wife or husband injured. We wanted it to be, and that's why we got the drug companies off the hook, so they wouldn't be sued and have endless litigation, so they could produce these pharmaceutical supplies. And so the intention of Congress, as I recall, because I was here and you've only been there 3 or 4 months, was that we make this a lot less adversarial. And as I said, I'll be happy to bring before this committee as many people as you want. I can bring maybe 50, 100 people at different times to tell you about situations like we heard this morning. So for you to give the impression to this committee and to the Congress that there's not a lot of problems out there, there are a lot of problems. And we haven't brought the attorneys before the committee who have handled these cases. The thing about the attorneys is they're limited, as I understand it, to $30,000?
That is incorrect.
How much are they limited to? Is there any limit?
They're limited in retrospective cases, but if the cases are not retrospective, meaning the injuries are post-act cases, there is no limit.
Well, we had the one case that we heard about a while ago where the attorney worked for almost 10 years and was given $30,000.
Mr. Sword's case.
Yes.
That was a retrospective case.
Well, I understand, but the point is, if you're trying to get a legal counsel, to take on a case like this, and they have to spend 5, 6, 7, 8 years trying to get the case resolved, a retrospective case like you're talking about, there aren't many attorneys that are going to do that because they're not going to do it on a pro bono basis. That means no cost basis. They're going to want a fee, and $30,000 for 10 years on a retrospective case is nothing.
Mr. Chairman, I couldn't agree more, but unfortunately, we have to abide by what the Act tells us we have to abide by.
Mr. Burton, I might add that the deadline for filing retrospective claims expired more than 10 years ago, so that the cap on attorney fees cases has not been a problem for people at all for the program for well over 10 years. That only applies to the vast majority of claims that were filed for injuries that occurred prior to 1988 when the program went into effect.
Let me get back to that. My time has expired, and Dr. Weldon's been very patient as well as Ms. Davis, so I'll let them have some time. Dr. Weldon.
Thank you, Mr. Chairman. Can either of you gentlemen tell me if you'll be sending somebody down to do the life care plan on Janet Selke's daughter, Rachel? She's been waiting since July. Is that handled by your office, Mr. Balbier, or you, Mr. Harris?
I think the policy typically is we don't assign a life care plan provider until we've received the life care plan from the petitioner. And beyond that, I'll let
she has sent it to you. In light of the fact that her case has been going on for 12 years, can you get somebody down there before Thanksgiving?
Tom, you want to?
Representative Weldon, one of the initiatives that came out of our advisory commission was the idea that we could develop life care plans using one life care planner for both parties. That is, for both for the petitioner who has filed a claim and the government who has to implement the statute. In the cases where we've been able to use what we call a joint life care planner, that has tremendously helped the resolution of the case, and we've been using them for many years. However, that's at the beginning of the damages process. If the family and their attorney agrees with using the concept of using one life care planner, it goes very, very quickly.
Well, you know, we heard testimony from her. She's lost a job. She can't work. She's had tremendous out-of-pocket expenses. It's been going on for 12 years. She hasn't heard a word since July. I'm just asking you a simple question. Can you ask somebody in your office to call her and set up an appointment to get the life care planner down there? You can't answer that question? Why not? As I understand it,
are you asking that question, gentlemen? Are you asking that question, Mr. Balbier?
Yeah.
I'd like to answer that, actually. It does seem like a very simple question. The honest answer is there may be a life care planner on the way right now. I honestly don't know. No, I can't answer that question
I think
right
the
now.
answer is
but we can
who
find
makes
out.
the decision? Who decides when somebody goes down to Florida? And Cat, got your tongue? You're looking at me like, is it whose office? Is it Justice or is it the vaccine program?
While the damages negotiations are underway, the Department of Justice trial attorneys handle most of that. We offer assistance wherever possible. And again,
okay,
there would be
so
no
it's you,
need
Mr.
for
Harris?
a life care planner to go down there had we been able to go with just one. That really helps resolve cases quickly. And we've had many cases resolved that way.
So you're saying you may accept the plan that she submits rather than send another person down and negotiate the plan?
Mr. Walden, what I'm saying is that
Are you, the reason you're not responding to me, is it because this is all in negotiations? Is that?
well, as you know, with any case that's under litigation, you can never comment on negotiations. This is litigation. We try to make it as less adversarial process.
Let me just ask you a very bland question, okay? Can you try to expedite this case in the months ahead? Is there a place in your heart to find a willingness to expedite this case?
We try to expedite every case. When I first saw, and it was just yesterday, which witnesses would be here testifying, which families, I recognized the names. I recognized them, although I didn't know immediately why. When I looked into it, I remembered that the Zolke's case was one of the lengthiest proceedings in the history of the compensation program. The facts in the Sword case stand out. When you first see them, you think, why would the government ever appeal this case? And then when I heard of the other witness, the name was also familiar, Rogers. That was familiar most recently because
well, let me ask
Congressman Burton asked me about that case.
Let me ask you another question. She has, Janet Zolke.
I might be able to.
Pardon me?
I may be able to help you out here.
Okay, go ahead.
If you'd like.
If you can make it quick.
Yes. I did not come prepared to discuss specific details of the Zolke case, but I can assure you that I will have one of our attorneys contact her attorney
all right, I'd like another
by tomorrow,
assurance.
and I'll be happy to get back with you on that.
I would like another assurance from you
Yes,
that
sir.
you will not seek any retribution against this lady and her family based on the testimony she has provided here.
Well, let me make it clear. The Justice Department never seeks retribution, and we're, in fact, would find it offensive for folks to characterize honest federal government employees as seeking retribution against U.S. citizens who suffer such a loss, and we wouldn't do that.
Mr.
And
Harris,
we have never done that, and there's no evidence to support that.
you draw your employees from the ranks of the human race, and you may be a very, very nice person, as may be Mr. Balbier, but as we all know, dealing with every federal agency, there are occasionally some people who will do things like that. So I would just ask that you would take some personal interest in this matter to make sure personally that nothing of that nature happens.
I will take a personal interest in this matter, and I can assure you that in any instance where there is an allegation that our attorneys are acting in an untoward fashion.
I'm not saying there's any allegation. I'm a little
because
concerned because she has said some things here that, a lot of people would be afraid to say.
Right. I understand that, and I'm sensitive to that, and I'll look into it, make sure that her attorneys are contacted. But I have to reiterate, there's no tendency on the Justice Department officials to seek retribution against citizens. And if you have evidence of that, I'd love to have it.
No, I don't have any evidence of that. I'm just being cautious. Thank you.
I'll be glad to talk to you about a few cases after we adjourn, because there has been some cases of what I would consider retribution. I think you probably ought to be aware of. The other thing I'd like to say before I yield to Ms. Davis is this. You're going to respond to Ms. Zelke's problem by calling tomorrow. What about the other people that we can bring in, and I'm sure that there's probably over 100 or maybe more that would require the same kind of attention that haven't received it? Should we give you a list of those so that you can respond to those quickly?
Mr. Chairman, if you have a list of folks that we haven't contacted in months, I'd love to have a list of those folks.
Well, you're going to get it.
Well, I appreciate that.
I will have that for you. And since you've been on the job a short time, I think that maybe you are going to be able to make a difference, and I'll get you that list. Ms. Davis.
Thank you, Mr. Chairman. Mr. Harris, I know you've only been on the job since July. Mr. Balbier, how long have you been involved with this?
For about a little over 11 years, I've been the director of the program.
So you're pretty familiar with all three of these cases, and then you made a
No,
comment.
I'm not. I wasn't really.
Well, you said you
I was familiar with
recognized
the
the names right
histories.
off.
The names were familiar when I first heard of them, and again, that was only just yesterday when I saw the witness
But you
list.
made a comment a minute ago that, based on the facts, you had to wonder why the Justice Department appealed. I think Mr. Swords is who you said.
Well,
and that's the one, if I'm not
that wasn't-
mistaken, well, let me finish. That's the one, if I'm not mistaken, that they just said that it was appealed and it was lost. So who makes the decision to appeal? Does HHS recommend it, or does DOJ look at it and make the determination? Who makes that determination?
That's an excellent question. We make the determination together. However, it's really up to the Department of Health and Human Services. We are the ones who are responsible for administering this program. Our pediatricians are the initial reviewers of cases after they're filed. They make recommendations to the court. They first prepare a medical report, and then in cases where we can see that they met the criteria of the statute, we move immediately to damages negotiations, and we've had cases resolved in as little as 97 days.
Okay, so you just said...
But in cases where they don't meet the criteria of the statute, that's where problems arise. People, reasonable, honest people, good families have very different opinions on injuries that are, surrounding the administration of vaccines and whether they seemingly are caused by vaccines. And as I said, with the Zolke case, I remember that case years ago when we first got a congressional inquiry on the case. And that was my reaction. Why did we appeal this case? It wasn't fresh in my
Zolke or
memory.
Sword?
No, Zolke. I'm
Okay.
sorry.
But did you not say a minute ago when you were talking that on the face of it, you didn't understand why the Sword case was appealed? I believe that's what you said.
Okay. I'm trying to remember what the...
Mr. Sword.
Yes.
The one that was appealed and was won.
It's the Sword case. You're right. It's the Sword case I'm thinking of. That's correct.
You lost when you appealed it.
Well...
So I guess my question is, I'm assuming then that HHS recommended to DOJ.
That's exactly
to
how
appeal
it works.
But you're with HHS.
That's
you
right.
just said that when you looked at the facts of the case, you had to wonder
I
why
raised
it
the
was
question.
appealed.
Why did we appeal? I looked
And then you
into it,
lost
and I had a very good answer to that question. My
Okay,
staff
I'd like
filled
to
me
hear
in.
it.
I'd like to be able to tell you that.
Okay.
That case is in litigation. I can't.
I thought you just said it was lost. Did you
That
not
case
just
is
say
still
that
in
the
litigation.
Sword's appeal was lost?
As far as we're concerned, all these cases are in litigation, and we cannot discuss them.
I guess, Mr. Chairman, I'm sort of confused here.
If the gentlelady would yield, as I understand it, they're in litigation, not on the outcome, but on the amount of compensation. Is that correct?
As I said, I cannot discuss these cases. They're on appeal. I can't discuss what the issues are in these cases.
But I believe...
Swords, excuse me, gentlemen, swords you can't discuss even though that's been completed?
The case actually has not been completed. I don't believe that case has been paid, has it?
The money's been paid, has it not?
The Sword case is a closed case, Mr. Chairman.
And you can't comment on that, Mr. Balbier? You can't comment on the Swords case?
I did not come here prepared to comment on the Sword case and the specifics of that case. As I said, I didn't know that.
Well, I want you to know that you guys are going to be up here more than you ever dreamed you're going to be up here if you don't cooperate with this committee. And hiding behind a case that you say is ongoing and you can run it on for 8 or 10 years is not going to be acceptable. Now, I hope you get used to looking at me because you're going to be up here a lot. And if you don't want to come, I'll subpoena you. And if I have to go to Tommy Thompson and have him bring you up here, I'll do it. This is ridiculous. Gentlelady's time, I'm sorry.
That's okay, Mr. Chairman. I guess what concerns me, Mr. Balbier, is you're sitting here stating that you cannot comment on a case, yet you yourself, without being asked the question, commented on the case a minute ago when Representative Weldon was speaking, and you said that when you looked at that case, you couldn't understand why it was appealed.
That is
then
correct.
You answered the chairman that the appeal had been lost. So I guess I've got a real problem as to why you make a comment that you don't understand why you appealed it. You just answered me that HHS
I was
makes
simply
makes a
confused between the two
recommendation.
cases.
Well, if you've got your memory back now, can you tell me why you appealed it?
I didn't come here to prepare to discuss the merits of that case.
I
don't have the specifics in front of me. We can, if you would like, we can provide for the record the case history of that case and why it was appealed and the issues involved. They are complex.
I'd like to be able to help answer some of your questions if you would permit me to do so. Just to clear up where we are with the 3 cases that we heard from this morning. The Sword case, to my understanding, if I recall correctly, it's a closed case, and payment was made on that case, I believe, in August of '99. Is that correct? And there's one case pending on damages, which is the Zolke case, and there's another, the Rogers case is pending on appeal. So if you have questions about the Sword case, I think I'd feel comfortable in answering those questions. And if your question is, why was that case appealed? It was appealed because we disagree with the theory used by the special master in determining that case, because it was a theory that was not discussed in the litigation process. Because it was not discussed in the litigation process, we did not have our opportunity to present our side of her theory. Once the special master made a decision, we tried to introduce evidence that would, in effect, present our side of what her theory turned out to be. She decided not to hear that. We appealed to the Court of Federal Claims. The Court of Federal Claims agreed with the special master, and we decided not to take it any further. So that's where that case ended. I think it would be safe to say that because of the appeals taken in the Sword case, it was protracted out over months. However, once the decision was made by the Court of Federal Claims in June of '99, payment was made to the family by August of that year.
Thank you, Mr. Harris. I don't know if it's appropriate to make this comment, Mr. Chairman, but I'm going to, and you can call me down if I'm incorrect. But I can understand, Mr. Valpieri, why the petitioners feel an adversarial role from the government, because I felt an adversarial role from you when you responded to me. Thank you, Mr. Chairman.
I apologize if you felt that way. That was not my intent.
Oh, sorry. Mr. Platts, I'm sorry. I didn't see you down there. Do you have any questions?
Actually, maybe just one to follow up, Mr. Chairman. Ms. Davis, it sounded like, Mr. Valbier, that you have an answer. I understand you didn't come prepared to get into specifics, but it sounded like you have an answer to the question about the appeal when you asked and you looked at it and you were given an answer, but you didn't think you could share it because that was a pending case. Now that we've resolved that that is a closed case, the answer that you apparently wanted to give but thought you couldn't seems like you can now give. So I'd be interested in hearing that answer.
I think in the Sword case, the medical issues were very complex. I had them explained to me very late last night by my medical staff, and I understood them at the time, and I understood why we appealed the case, and I understand that there was confusion or misinterpretation of the findings of the medical experts in those cases, and we decided to appeal that case based on the interpretation of the statute by the special master.
Okay. Thank you, Mr. Chairman.
The gentleman yields back. The chair now yields to himself 5 minutes for a second round of questions. Mr. Balbier, am I pronouncing your name correctly?
Yes, sir.
You said in your testimony that you have done a lot to let people know about the program. Mm-hmm. Have you done a study or a poll to see what is the level of awareness on the part of the public of the vaccine compensation program, specifically parents of newborns?
Parents of newborns. We have not done any studies to date to do that.
I would recommend you do so because one of the themes I've heard over and over again is that people hadn't heard about the program. And I think we would be well served to get some sort of measure, objective measure of what the level of awareness is, and it may help us in the Congress to work with your agency to raise the level of public awareness. I also want to say to you that I appreciate the endorsement of many of the provisions of the legislation introduced by Congressman Nadler of New York and myself, H.R. 1287. Would you be willing to commit to sit down with my staff or members of your staff, with my staff, to see if we can work out acceptable language to the administration on some of these reforms that both Congressman Nadler and I and you would like to see move forward on?
We'd be happy to do that.
Thank you. I will have my staff set up a time for that. I personally believe we should be able to pass these reforms in a bipartisan fashion. Mr. Harris, as I understand it, if a family retains an attorney and puts in a claim, it goes before the program, and the program has pediatricians, basically, that analyze the merits of the case. And if the decision is made by the vaccine program managers to deny compensation, it's turned over to you, and then you oppose a settlement. And if these cases go before the special master, you actually have the ability to bring in experts. Is that correct?
That's correct.
Okay. Well,
and the petitioners, I might add, have that as well. One of the problems that petitioners face once they pass the eligibility phase, or the fact that they are eligible for the program, is the expense involved in hiring. And we're sensitive to that. And if your bill proposes to provide some fees to help in that, that would be something that we would certainly support.
Okay. Well, that was the kind of answer I was hoping to get. That's a complaint I've heard over and over again, that some of these attorneys are big-hearted enough to just wait and wait and wait years and years and years to get their payments, but it's impossible for them to be paying out for these experts. I was very, very disturbed in reviewing the case of Ms. Zulke. These repeated delays from DOJ, no explanation at some of these hearings why they were asking for continuance. Some of these continuances going on as long as 9 months is what my constituent complained to me. The impression I get just from listening to her, I'm reading between the lines here, it was often just the case the attorneys were not prepared. I don't believe that is acceptable at all. You said you took this job in July. What did you do prior to July?
Well, I practiced law, and I was also a state legislator in the great Commonwealth of Virginia.
Wonderful. I think we've met before, haven't we? No?
I don't think so.
Okay. It's quite all right. You didn't practice specifically medical malpractice or medical defense, did you?
No, Congressman. My practice was primarily labor and employment law, although I'm familiar with medical malpractice issues.
Okay. Well,
and I would add that I would hope that I'd have, and I think I do, a congressman who is as interested in representing their constituents as obviously you are for Ms. Zulke. I find it I would find it unacceptable for lengthy, unnecessary, unsubstantiated delays in cases, and I want to assure you that I will look into that. I also think the point that you made about making sure that parents are aware of this program is a very good point. And for our part, our attorneys and HHS officials, we regularly attend conferences both in the legal community, medical community, to try to make sure that information about the program gets out to the general public, and we distribute packets with information in it. This year, we attended 11 such conferences, and certainly we hope to improve on that number next year. But your point about making sure that families who are not aware of this program become aware of it is a well-taken point, and to the extent that we can help with that kind of outreach, we welcome that opportunity.
Well, the reason I was asking you about your background is, as maybe I made aware earlier, I'm a physician. I practiced medicine for 15 years before I was elected to the House of Representatives. And I happen to know the pediatrician pretty well who takes care of her daughter. And he's a Duke graduate. He's a really smart guy. And when she first brought her case to me, I actually read the chart. And you screwed up, basically, in my opinion, on this case. Unless you've got information that you're not revealing, dragging this one on for 12 years is really bad. And it makes the program look bad. It makes the Congress look bad. And I would highly encourage you to come to an expeditious resolution of this case. And I'm certainly looking forward to working with you in the weeks and months ahead in crafting ways that we can try to improve the program so that it better meets the needs and intent of Congress. There's universal agreement that it's too adversarial. I understand your comments, Mr. Barbier, that the way we wrote the law, it's still adversarial. And I accept the responsibility for us to make it less adversarial. I also recognize the importance that it be based on good quality medical science. Excuse me 1 second. You do? Today we have heard that some of the special masters handling compensation cases were frustrated by or angry about Justice Department conduct. They made comments like embarrassed. They called prosecutors abrasive, tenacious, and obstreperous. They called arguments egregious. Obviously, you can see why we are concerned. Mr. Harris, do you agree with these observations?
No. I think that our attorneys do the best job they can. They act professionally. They act with compassion in these programs, but they also have a professional responsibility to abide by the standard and criteria set by Congress, which is a preponderance of the evidence standard, which means that basically the case that the petitioners present only has to tilt just the slightest bit in their favor, in which case compensation awards are paid. I know that the remarks that you made there from a special master pertaining to one of our attorneys was, believe, made in the Mann case, and I would have to put those remarks into some kind of a context, look into the case, and be happy again to get back with you with what we discover. But as a rule or something that happens even infrequently, of course not.
Well, when comments are made like that by a special master, it reflects very, very poorly on the Justice Department. And I would hope that you would take a appropriate action in your new position to make sure that you do not have attorneys working for you that would engage in practices that would precipitate those kinds of comments by a special master.
I certainly will do all I can to make sure that that kind of conduct obviously does not take place within the department. I feel very comfortable at this point in saying that it doesn't. And I believe that, I mean, you have to put comments into perspective. That same special master who derided our attorney was described as worthless in the prior panel.
Well, I appreciate you sharing that. I know the special masters are drawn from the human race as well, but the comments made in the Mann case are not unique. There have been other similar types of complaints. I'd like to now yield to the chairman of the committee, the gentleman from Indiana, Mr. Burton.
Thank you. Thank you very much, Doctor. I just had a couple follow-ups on this question. It says, when you have those kinds of comments made in a hearing where the special master says that they're embarrassed, what they call the prosecutors abrasive, tenacious, obstreperous, do you guys agree with those comments that they made?
I don't agree with those comments.
Well, but you're pretty new. Do you agree with these comments?
I have never known. I don't know the context in which those comments were made, Mr. Burton, but I've known most of the trial attorneys at DOJ for quite a long time. There are some newer attorneys, but most of them have been with the program for quite some time, and that certainly, my experience has been just the opposite. The attorneys come before our advisory commission too, I mean, and work with the commission to try to make this program work better. So they've, our own advisory commission has had the opportunity to meet several of the trial attorneys at the Department of Justice over the years, and they've been more than cooperative, and I think represent us quite well before the court. If we had any concerns about the quality of representation, we would have made those concerns with the Department of Justice, but we've never had any problems at all in that area.
When a special master makes comments like those, do they have any place to go? Is there any review process? I mean, if they're talking to somebody over there at your department or Justice Department and they feel like that they've been meeting with people who are arrogant or obstreperous or abusive, where do they go?
Certainly when a special master makes those kinds of comments with regard to a Justice Department lawyer, we review it, as we did in this case.
Who reviews it?
The director of the department that oversees the vaccine program, and if necessary, I'll review it myself. But I can tell you that the special master has recently appointed this particular attorney who is the subject of these derisive comments to be chairman of the process group to work very closely with special masters.
Well, that sounds like a step in the right direction.
He's a quality individual.
Have we? Okay. How does the VICP select expert witnesses? Do you require them to disclose financial ties, either personal or institutional, with vaccine manufacturers or other government agencies such as NIH? And that's very important because I have subpoenaed the financial records of a lot of people that are on advisory committees over at HHS and so forth. And we have found some people who are on these advisory committees who are making recommendations on vaccines and so forth that have conflicts of interest. In other words, one of the fellows on the rotoshield virus, which I think one of the people on the advisory panel that Mr. Balber referred to regarding the rotavirus vaccine, he was the chairman of that committee, and he had a lot of stock in one of the companies that made the rotoshield virus, rotavirus vaccines. And what you didn't mention was that although the company withdrew the rotoshield virus from the market, it was because there had been so many adverse reactions, and it was less than 1 year after it had been put on the market, number one. And number two, there were several people on the advisory panel that had real reservations about that vaccine ever being put into the marketplace in the first place. But nevertheless, the chairman of that committee had financial ties to a pharmaceutical company, and it was put in the market. One child died, and several others had severe problems. And so what we'd like to ask the same kind of question. Do you require these people who are expert witnesses, do you require them to disclose financial ties, either personal or institutional, with some of these vaccine manufacturers?
As far as the, well, let me try to answer that question, because you asked about the expert witness who testify and also the advisory commission members.
Well, I didn't ask about the advisory commission members, because I already know. I've already checked. I've subpoenaed and got their financial records. They didn't want to tell me that, like you didn't want to tell us some things, so I sent a subpoena out, and I got the records. And we have found in their financial records, and so a lot of them are incomplete, which we're still checking on, we have found that they had financial ties to pharmaceutical companies, and we think that might have tainted their judgment just a bit. But nevertheless, we're talking about these expert witnesses right now.
Experts who testify.
Yeah.
No, we don't require that they, fill out any conflict of interest forms at all.
Why wouldn't you think that might taint their judgment just a little bit? Let's say, for instance, I'll give you an example. Let's say that a person had strong interests in a pharmaceutical company that manufactured a product, and that product was the one that we suspicion caused an adverse event in a child who was vaccinated. Would you think that that person would be an unbiased witness?
I would think something like that probably would come up in court, or could come up in court proceedings, but...
Not unless somebody asked.
Right.
I mean, your advisory panels over at HHS, nobody ever asked. Many of those people, they got a financial disclosure statement. Many of those were completely vacant. There wasn't anything on it until we checked. So an expert witness that's testifying, it seems to me logical that the first question to ask is, do you have any financial ties to the company that manufactured the product that created this adverse event? Seems like you'd want to ask that, wouldn't you? I will state that the hearing record will remain open until November 15th so that we can ask additional questions, and we'd like for you to submit answers to that. Let me just say this to you. We're going to have you guys back again very soon. I promise you. We're going to bring some more people up here, and we're going to ask you to sit there and listen to them. And I'm going to get you a list of the cases that we talked about earlier, as many as I can find, so that maybe you can follow up and maybe make their lives a little bit easier and make them feel like this government is responding as it should to very difficult situations that they're involved in. And I have to tell you one more thing. When you're in the bureaucracy and you're there for a long time, and you've been there for a long time, Mr. Valbier, you hear, I'm not so sure that maybe you don't become a little callous, not intentionally, but I think you do become a little callous because you hear so many of these horror stories. I mean, we don't hear that many, and so many of us up here, our heart bleeds for these people, but you hear them every day. So after a while, whether you realize it or not, maybe you become a little callous. Not intentionally. I'm not saying you're a callous individual, but there is an appearance of defensiveness and arrogance that sometimes comes across to people, and they feel not only that you don't care, they feel hopeless. And that's really sad. And so I would just say to you, because you're going to be there for a while, I'm sure. I can't do anything about that. I can drag you up here and beat you over the head, but I can't get you out of that job in all probability. But I wish you would think of one thing. When you talk to those people, they're suffering. They're hurting inside. They've got a child or a sibling or somebody that's really suffering. And so when you tell them no, or you give them, do it with a heart. If you do that for me, even though you and I may not like each other, you may not like me much because I'm such a hard nose. But if you would do that, it would be a real favor to me, because a lot of these people are suffering. And we'll have you back here again, and you can hear some more of their stories, and we'll get some more questions answered. And I will submit this to you, so you can take a look at that. And with that, do we have any other questions? If not, thank you for being here. We stand adjourned.
Ahead on C-SPAN 2, a briefing on preparations for bioterrorism attacks. And then another hearing. The House International Relations Committee looks at efforts to get humanitarian aid to Afghanistan. And at 10 a.m. Eastern, the U.S.